presiding administrator, and I'll be reviewing the cases on the wall by means of a PowerPoint for today's presentations. Again, as we talked about before the meeting started, cases without opposition will have 5 minutes to present their case, and you'll do so by coming forward to the table, pushing the button just to the right of the microphone stand one time and one time only, and identifying yourself with your name and address, and then making your presentation. In cases with opposition, both the applicant and parties in support of a case and the opposition and those parties opposed to a case will have 10 minutes per group to put on their presentation. Again, applicants will want to save some of their time for a rebuttal period after the opposition speaks. I'll go through all the cases set for public hearing today. The board will discuss and vote on the cases in front of you. The board is vested with powers to act under Section 1740-180 of the Metro Code of Law. The code requires that 4 members of the 7-member board be present to constitute a quorum. I have 4 members present now. I'm checking on the 5th, see if they'll be attending. In the event we only have 4 members present today, you've got to get all 4 votes in your favor for your case to grant. If your case does not pass, again, it'll stay on our agenda for 30 days. The members who are not present will be able to review the record and then participate at our next meeting on February 20th in this room. At that meeting, the members who were not present, I'll actually poll them individually, ask them if they've watched the record in a yes, no, and if they wish to participate in a yes, no, and then they will cast their vote that day. If after that meeting you still don't have 4 affirmative votes, your case will be deemed denied by operation of law. Let me correct myself. It stays on the board's agendas for 30 days. We will actually have 2 meetings within 30 days. So we'll do that process again on March the 6th. And then after the March 6th hearing, if you are still tied up on votes, and by tied up is failing to have 4 affirmative votes for your case, then you'll be deemed denied by operation of law. Board is set to go through all cases listed on the agenda today. And after, like I said, I'll go first and present the Codes Department's records, and then I'll turn it over to the applicant and those parties in support. All right. Before we begin, the board does allow elected officials to address the board. Are there any elected officials present with us today? Okay. I'm Chairman, seeing none. I'm going to call now the case recommended for the consent agenda, and if you're here on this case and you're opposed to the case I'm about to call, if you'll raise your hand, please, we'll hear the case in its regular order on the agenda. The first and only case recommended for consent today is case 2025-007. Aaron Godez, the appellant, Nashville Quality Homes, LLC, the owner of the properties at 1818 Ashton Avenue, requesting variance and side setbacks in the R10 district for a single-family residence. Are there any parties present opposed to case 25007? Okay, we will hear that case in its regular order at the beginning, and we'll start with our first case today. If you'll give me just a second. Our first case today will be, let's see if I can get that to work this time. Okay, our first case today will be case 2024-255, Home Capital, LLC, the appellant and owner of the property at 1411 Old Hickory Boulevard, requesting a variance from the fence height requirements in the R40 district, referred to the board under section 1712-040. The appellant has alleged jurisdiction under section 1740-1AB. See, the appellants are present. Are there any parties opposed to case 2024-255 on Old Hickory? Okay, good. I do have one hand back there. With that, let me reset the clock, gentlemen. I'll put on the presentation first, and then I'll turn it over to you all. All right, the subject property is located on the south margin of Old Hickory Boulevard, and I'll leave this slide up. This slide actually shows the issue under the code, and I'm going to attach a laser point. The zoning code permits solid fences or opaque fences to be both in front and rear yards and side yards, but they have setback requirements based upon the height of the solid fence. This particular fence is 6 foot in height. I believe these are 6 foot panels that are listed here. And to have a fence of this height in the front yard, they have to be at least 10 feet back from the right of way. And obviously we allow the applicant's going to have to tell us where the property line is there, but a good indicator upon my visit out here is you see where my red dot is this utility pole. Utility poles are generally located at the back side of a right of way, and that's not 100% true in all cases, but as a general rule of thumb. So the code for this fence to be legal where it's constructed would have to be 10 feet back from the edge of the right of way on Old Hickory Boulevard. And then once they cleared the 10-foot mark, it could be 6 feet tall. Inside that first 10-foot area that we were talking about, solid fences or opaque fences are not allowed to exceed 30 inches in height. Chain link fences, open fences are allowed to be 6 feet in height in the entirety of the front setback. And because they're open in nature, you can see through it. But that's the fence erected upon my visit out there on the 28th of January. Okay, gentlemen, I'll turn it over to you. That's case records. We have it. Gentlemen, if you would please state your names for the record. Again, a reminder, you'll have 10 minutes to present your testimony. You may want to save some of that time for rebuttal. And if you have an idea ahead of time, great. If you go on and you stop, whatever's remaining on the clock is what you'll have. And I'll turn it over to you after your introductions. I'll start the clock. Mr. Baker, can you hit that button just to the right of the microphone stand?
Sorry.
There you go.
Yeah, my name is Lance Baker. I'm an attorney for Mr. Quentin Wang. Mr. Wang is present here today. Mr. Wang
Excuse me, we need your address.
I'm sorry?
We need your address, name and address.
My home address or business address? Either
Business
one?
is fine.
Business address? It's, I can't even remember the number. It's Virginia Way in Brentwood, Tennessee. Mr. Wang owns the company, a LLC company called Home Capital that owns this property located at 1411 Old Hickory Boulevard. I have, as a preliminary matter, an affidavit of Mr. Wang. We didn't have a notary, and so, but he has signed it, and I'd like to submit this as a statement of Mr. Wang. And then I also have a series of photographs on like true photographs, and then I have some other photographs on paper, some of which are at night, and I would like to submit each of these photographs. Of course, the statement by the code authority is correct as far as what this falls under. This situation comes under the bulk setback provisions of the zoning code, and it's specifically 17.12.040 other setbacks, and talks about subpart E, permitted setback obstructions, and specifically paragraph E26, talking about screening walls and fences. The maximum permitted height measured from finished grade level on the side of the wall or fence with the greatest vertical exposure shall be 2 1/2 feet in height within 10 feet of a street right of way. And it's our position that the fence is within the 10 feet or very close to it. And Mr. Wang, he tried to do everything exactly correctly the way it was supposed to be done. He talked to the codes department and was told that this would be 10 feet, that it had to be with outside of 10 feet, and he believes this is 10 feet. And so 26A says 2 1/2 feet in height within 10 feet, and then 6 feet in height within the remainder. And so even if it's, as admitted by the Metro, it is no more than 6 feet. So it's initially the position that we're actually not even in violation here. But the Metro position is that the height of the fence, as I understand it, is in violation. So you turn to the 17-40-330, and and specifically 17-40-370, the review standards for granting of a variance. And the board shall not grant a variance without affirmative finding of fact on each of the following standards. A, physical characteristics of the property. B, unique characteristics. C, hardship not self-imposed. D, financial gain not the only basis. E, no injury to neighboring property. And F, no harm to public welfare. We have in Mr. Wang's statement that has been submitted to you, we actually address each of those factors that you have to consider. And the primary reason why for this fence is one of safety. And you'll see in the photographs that have been submitted to you, on a number of occasions, drivers have driven down through the road and either intentionally or unintentionally have driven over and knocked down his mailbox. And he also had right next to the mailbox, and there's another light that was at the far end there in this picture. He also had some lights to light up the entrance, and people were running over those lights. And you'll see in the pictures, you'll see where some electrical wiring in the ground, and that is what's left of his lights that he had there. So this was a continual problem. It was costing him a lot of money. It was unsafe, not just for him and his the people that use the entrance, but also to anyone that's just driving along through there. So his idea was to build the fence. You'll see it's a very nice fence, an expensive fence, and it contains lights all down through the fence row. And you can see it in the daylight pictures, and then you can see it in the night pictures that have been submitted as well. There are no street lights in this particular spot along the road. And adding this fence actually greatly increases the safety for drivers in this area because it lights up where this curb drop-off is. So it increases the safety in the area, and that's what he talks about primarily in his affidavit. Also, it screens, the house itself has very large windows and a very large double-sided front door that is easily seen through at night, and this provides screening. And I'm going to stop here in just a minute, but if you look at the affidavit, which I'd asked you to do, we addressed each of the factors of the physical characteristics, the exceptional topographic condition. It's on a very steep slope. It slopes downward. His house is down at the end. And the specific unique characteristics is that sloping nature. He actually he's not going to gain anything financially by having the fence or by being granted a variance. In fact, it's cost him a lot of money to build this very nice fence. And I want to address the no injury to neighboring property. He has a U-shaped driveway, and there's property owners obviously on each side. And as you can see from this picture, for both entrances, once someone pulls up out of the driveway and gets ready to enter Old Hickory Boulevard, you can still see with no problem down Old Hickory Boulevard. So that's not a problem. There's no injury to neighboring property owners. And in fact, I would argue that it's actually helpful to them because it provides lighting in this very dark area of road. It helps them find the location for their own entrance, and it helps drivers and the public generally to see where the edge of the roadway is, which you can't really see at night but for these lights because there is no street lights in the area. And finally, there's no harm to public welfare. I'll reserve the balance of my time.
Okay, does anyone have questions? No? Okay. Was there opposition? Okay.
We'll slide down.
Okay, if there are no questions, we'll hear from those parties opposed to this case. Gentlemen, if you guys don't mind, just take a seat back on the front row there, and I'll reset the clock, and parties opposed to the case come forward this time. Again, sir, as you come forward, please identify yourself, name and address, and present your testimony to the board.
Are we on? Good afternoon. Thank you for your service on the board. My name is Ben Matthews. I live on Panorama Drive in Brentwood, Tennessee. I am here to speak on this issue. The applicant has alleged that the board has jurisdiction under section 40.180B, which allows you to consider variances, but requires the applicant to submit to you a written application on forms provided by this board. That is under section 174350. I have not heard of a written application being submitted to this board. We've heard of an affidavit that's being given to you today, but I certainly have not seen that and would be interested to see if the applicant would comply with those requirements. The application is required to include a site plan. There appears to be some ambiguity about where this fence is located with regard to the right-of-way in the first place. According to the publicly available mapping data, the fence sits flatly inside of, could we put that picture back up? It would be helpful. According to the publicly available mapping data, the fence sits flatly inside the right-of-way, not 10 feet outside of it, but all the way inside of it. I do think that it would be helpful to look at the criteria that you have to analyze in order to determine whether to grant a variance. This is probably no need to remind the board, but you are required to issue findings of fact on all 7 of the physical characteristics of the property that the applicant is asking you to make findings under 174370. This fence sticks out like a sore thumb because it is the only fence of its kind that is 6 feet tall. And you had a measuring tool, sir. Could you tell us how far it is from the actual road?
I am not a licensed surveyor, so no, sir, I can't.
Okay. Do you want to bring up that picture you had just a second ago?
Mm-hmm. These?
It was a diagram, black and white.
Oh, that was the site plan submitted by the applicant.
Okay. The typical fences in this part of town that are located within 50 feet of the road are about 2.5 feet tall. Most of them are made out of rock. They're very attractive. The fence next door to this property is 2.5 feet tall, or 30 inches thereabout. There are no bare wood fences 6 feet tall within 20 or 30 feet of the road, and there's a reason for that. It sticks out. I do not feel like the applicant who bears the burden of proof here has demonstrated to you that there are specific criteria that would require a 6-foot fence. You heard about a mailbox that was run over. If we could bring the picture of the mailbox back up. This fence is going to do nothing to protect the mailbox. I am sympathetic to the fact that a mailbox on Old Hickory Boulevard is subject to being run over, but that may just be part of life on Old Hickory Boulevard. That fence is not going to do anything to alleviate that issue. I do not think the city would want to encourage private residents to be illuminating the street. That is a job for the public welfare provided by the city. Whatever ancillary benefit someone traveling 40 miles an hour down Old Hickory Boulevard gets from these little lamps does not outweigh the fact that this is not even close. It's almost 3 times the required height of a fence that is within 10 feet. And from my view, this could actually be inside the right-of-way. I do feel like the applicant failed to address the third item, which is whether the hardship has been self-imposed. It does appear that the applicant took it upon himself to build this tall fence. I understand that it would be expensive to move it. I understand it would be expensive to change the size, but these codes are available to us all and could have been reviewed before the fence was built. That sounds like a self-imposed problem to me. With regard to harm to the public welfare, I have covered that issue simply with regard to the difference and the distinction between this fence and every other fence in the vicinity. With regard to injury to neighboring properties and the potential to significantly diminish or impair property values within the area, I think the fact that the fence stands here 6 feet tall right next to the road in opposition to every other fence within a 2-mile stretch of Old Hickory Boulevard speaks for itself. And then lastly, I have a safety concern about this fence. It is close enough to the road that if it were to blow down, it could actually end up in the road. That issue would not be present with a smaller fence. It would not be present with a fence made out of different materials. At the end of the day, I think that it would be wise to consider the factors that have been sent to you via email from the other residents that live nearby. And I also think that the city ought to consider the fact that these siting characteristics are available to us all. And I do not see enough extenuating circumstances here for you to grant a variance. And so I would ask you not to do that. Thank you.
Any questions from the board? No? Thanks.
If you'll, as we've submitted the statement, the affidavit of Mr. Wang, again, we address all of the factors, the standards for a variance, the special, unique physical characteristics of the property, the exceptional topographic condition that places a hardship on him and exceptional practical difficulty because without the fence, he's going to continue to have these safety problems. His mailbox is going to keep getting run over. His lights are going to keep getting run over. There's also, we addressed the whole issue about the unique characteristics of the property. The hardship was not self-imposed. It's due to the topography, the strong slant of the lot. He doesn't get any financial gain. There is no injury to the neighboring property. And you can see from the pictures, it does not affect the line of sight for anyone pulling into or out of the neighboring properties. And in fact, also I want to address that the previous speaker said there's no other fences in the area. I'd like to submit this photograph. This is less than a quarter mile away on Old Hickory Boulevard, wooden slat fence, approximately 6 feet tall. So yes, to say that there's no other wooden fences in this area is simply not true. And to address his issue about was there an application, is there a site plan? The codes director pulled that up. We did in fact submit a proper application. We did attach a site plan and it's and we attached even pictures showing you where the mailbox had been knocked down previously, actually a picture of that. And I assume that's all part of the record. If not, I'd ask to make it a part of the record. And I'm open to any further questions.
Do you have a survey of the property showing the location of the fence on a survey?
I do not have one. We would be happy to procure one.
Okay, it doesn't appear there's any further questions, so we'll, no.
So in conclusion, what I would say is Mr. Wang's position, our position is that he doesn't even require a variance. Secondly, if one is required, he's met all of the standards for this board to grant one, and he respectfully asks you to remedy this hardship for him that is actually best for the public, the drivers in this area, because it is so dark at night without the fence. And it's a nice fence. It's a beautiful fence. I'm sorry. Oh, yeah, he's going to be putting some landscaping in, low-level landscaping in the front. And so this is a very nice addition to this property. I would submit it not only increases the value of his property, but even increases the value of the adjacent properties because it increases safety. It certainly doesn't decrease the value of those properties.
Mr. Baker, do you know how many feet the residence is set back from the street?
I'm sorry?
What's the distance from the front of the residence to the street?
It's, I have a picture of that. I don't know the exact distance, but it's the front of the residence is a considerable distance away. But it's a strongly sloping downhill slant. And there's a U-shaped driveway that comes right in front of, you can see here, there's the U-shaped driveway and there's a house, and it actually comes right in front of the house.
On your diagram that you provided,
Yes, ma'am.
you show a 10-foot dimension.
Mm-hmm.
So in this photo, is that 10 feet measured from the white line on the road?
I believe so.
Okay. That is likely not your property line. I hate to say that. That's why we would need to see a survey to see the exact location of it.
He was informed that that would be where it would be measured from. And he thought he was good.
Now, we understand, but property lines are often off the street.
I understand.
Yeah, we wouldn't know without a survey.
I have one question.
Yes, ma'am.
I was going to wait till ask Joey the question about determining exact location of the property line or right of way. Because, as Chair Kapnick said, there is no survey for us to determine the exact location in relation to right of way. So that's the problem. But in your application, it says additional 40 feet setback. So that's 40 feet number. Where did you obtain that number? And who said additional 40 feet will be required?
Yeah, the codes officer.
So you didn't get that 40 feet number before you build the fence up?
You want to answer that? Go ahead.
That is correct, ma'am. So
You'll have to, I'm sorry, you'll have to identify yourself and your address.
Oh.
I don't recall if you had done that already.
my name's Quentin Wang. I'm a property owner.
Okay. And your address is the one listed here,
Yes.
1411 Old Hickory?
Yes.
Okay.
So the codes office, I called in before I built do the construction, and I told whoever on the other side of the phone, I said, I have a house on Old Hickory Boulevard, and I said the exact address, and she said, the representative said, as long as you're 10 foot away from the main road and you're less or equal than 6 feet, you're good. That's how I get started. And then the officer came over and said, you're on the right of way. I did not even aware of that until that day, and I realized there's only 4 houses on the entire street that's with the right of way, which is this house and 2 other houses on the side. And he said you got to push down 40 feet before you can start building. And if that's the case, there's no point for me to put a fence there because it's a significant slope of the driveway. Yes.
And it would not aid in the safety factor because that would be so far
Your mic
away,
is
the
not
lighting
on.
would not light up the road and the entrance.
When you talk, please push the mic on for the public purpose.
Sorry.
If you would repeat your.
Oh, if the fence have to be relocated, moved back that far, then it does not serve its purpose of providing the lighting of the entrances to his property and to alert drivers driving along Old Hickory Boulevard that, look, the edge of the roadway is right here. And to help stop people from running over his lighting that he had, which was located near the mailbox at this particular entrance, and then there was another lighting at the second entrance. And you'll see the pictures, we've shown you where the locations were of the wiring in the ground. We've submitted that.
appreciate your answer, but I am still requesting the survey because determining right of way and property line is very, very important to determine the actual requirement. Without that specific information, it would be personally hard for me to determine whatever your testament might be. Thank you.
Right. And we would be happy to provide that to the Board of Zoning Appeals at a later meeting. I will say this, though, even if it's within the right-of-way, we can still build the fence. That's what is authorized, but it's the height that's at issue. And so if that is the big concern, what we would simply ask, one of the powers and duties of this board is you can impose restrictions and conditions, and you can fashion a remedy for it. And instead of actually tearing the whole fence down and moving it, one thing you could do, we don't want to do this, but you could say, well, we're going to let you leave the fence, but you have to reduce it by a foot or two. I believe Mr. Wang would be open to doing that, to reducing it down to the level of the lights, for example, reducing the height.
Let me clarify something. If that fence is in the city's right of way, it will have to be moved out. This board cannot grant permission to construct anything within the city right of way.
I understand.
Okay, I just want to make sure.
Okay, any additional questions? Okay, then do you have anything additional to add?
No, just that, our position is that it's not in the right of way, so.
Okay. We'll close the public hearing then and open for discussion. I'll start by saying I agree we need the survey to really understand what the matter at hand. So I would recommend we defer the case for a meeting or two.
I agree completely. I think it's in both the applicant's interest and everybody's interest that we not, make a call until we have a survey that can cleanly demonstrate the property line. At that point, too, it may become clear to the applicant that if the fence is indeed sitting in the right-of-way, we may not need to come back here at all, based upon what Mr. Hargis said. So I would second that motion that we defer.
Okay. Any other discussion on that? So I'm going to make a motion to defer one meeting. If the appellant, Joey says 2
Yeah,
minutes.
can we do 2? Because it's going to take them a little bit of time to get a surveyor. And just for the board member and the public, our next 2 meetings are February 20th and March 6th. We currently will not have a March 20th meeting. We had no cases filed. It's the first time in 25 years. But
Oh, wow.
yeah, strange. But
Please knock on wood.
I'll knock on wood, but we may have keep that on your calendars, members, because we may need to talk about rules of procedure. So,
Okay.
but those will be the next two meetings, 2:20 and 3:06.
Okay, so the motion is to defer 2 meetings. Is there a second on the motion?
Second.
There's a second. There's a motion, a second. Any discussion? All in favor, say aye, raise your hand. So 4 in favor, none opposed. And if you do find the fence is in the right of way and it needs to be taken down and you don't come back to the board, please speak with the codes department and
Yes.
really understand where the fence needs to be placed.
Yes, ma'am.
We see this a lot, unfortunately.
Yes.
Okay, this meeting's deferred till March the 6th. This is the notice for that meeting. No other notices will come out. If for the applicants, if by chance you do not have the survey for March 6th, let our office know. If it's pushed beyond that into April, we will require you to send out new letter notices out.
Thank you.
Off the mail list, but thank you. Okay, members, just clarifying for all parties present, we will only have 4 members present that you see here today. I missed out on Mr. Cole's email alerting me from last week that he wasn't going to be here. But, okay, our next case is, let me bring up the, oops, that's not it. There we go. Okay, members, let you in on a personal secret. I'm a huge James Bond 007 fan. So, for any case that has 007 on it, you're going to get this graphic. So our next case is case 2025-007. Please do not hold that against the applicant. Hold it against me completely. Let's see here. Aaron Goda is the appellant. Nashville Quality Homes LLC is the owner of the property at 1818 Ashton Avenue, requesting variance from the side setbacks in the R10 district. The applicant's constructed two single-family residences on the parcel and referred to the board under section 1712-040. The applicant has alleged jurisdiction under section 1740-180B. Is the applicant present? All right, come on forward, sir. I'll give a presentation first, kind of like you saw last time. And for those parties, we do have opposition present. Just a reminder on the last case, opposition, you get one shot at the board to talk to them. So be sure you get something out. But the applicant does get a period for rebuttal. Okay, the subject property is located, as you see here, the parcel in red. This is a HPR-style duplex that's been constructed on the lot. They are two freestanding structures. This is the site plan, this is the as-built survey that was submitted by the applicant. The site plan submitted showed to the codes department the two residences that are 6 feet apart. I did not include that in the slide, but the issue here is along that northern property boundary. The as-built survey bears out that they are inside the 5-foot setback with the home, and so they are needing a variance at 4.5 feet is what I looked at on the survey there. I believe the home in question is the home to the left. Is that correct? Where the white vehicle is sitting, the darker clad home of the two. It would be along the property line just to the left of that, and I apologize. I got a little bit turned around when I shot pictures out there. So you're going to see a lot of photographs of the adjoining house, but so that the house in question is this home. Find my pointer. This home here, and it's along that common property boundary with the blue home that you see, and that's where the violations occurred, along their common property boundary at should be 5 feet. They're inside the 5-foot mark. The bottom left photograph was my attempt at shooting the very poorly into the sun that morning. But this is the view of the homes on my visit on the 29th of January. Gentlemen, you would please, as you saw in the last case, identify yourselves, name and address, and make your presentation to the board. And then you'll have 10 minutes as soon as I reset the clock here. And I'll start the clock after your introductions. And then you'll want to save a period of your 10 minutes for rebuttal of the opposition. Okay?
Hey all, my name is Randy Williams. I'm with United Veterans Construction Incorporated. I'm here today to help Eddie Angola.
Sorry, again, your address.
I'm here today to
address,
help.
please.
Good. Oh, the address? I'm sorry. 9853 Split Log Road, Brentwood, Tennessee. I'm here today with Eddie Angola. This was not any malintent involved in this. There was no. He wasn't trying to take advantage of a setback line. He wasn't trying to steal property out of it. All the other setback lines in the property are lined up. What had happened is we paid for a surveyor. The surveyor went out there. The concrete guy marked it as the inside of the wall instead of the outside of the wall, and so I'm off approximately 6 inches. And again, you know, so instead of a 5-foot wide access between the fence and the property, it'll be about 4.5 foot. And we apologize. Like I said, we weren't trying to impose on anybody. We weren't trying to steal anything away. I mean, 6 inches is about that much. And I know it's you know, you have the rule and everything, but we're just trying to save from having to rip that wall down and rebuild the wall 6 inches in there. It's just gonna, you know, There goes all the profits and part of the cost of construction. I know it's not your fault, but anyway, I just want to let you know that more than anything, that we did hire a surveyor. We went off it, and due to a miscommunication, we ended up on the wrong side of the pin, and for that, not only apologize, but we ask a variance given towards the property at this time. I'm not going to make this long and drawn out. I'm not going to go through a bunch of things. I'm not that kind of guy, but we are sorry. I mean, this taking up your time with this, and the neighbor, we apologize to the neighbor. We didn't do this on purpose. This wasn't, we're not out there to steal land from anybody, but the person that's going to be most affected would be the person, if they buy the unit, will only have 4.5 foot between the fence and the house to push a lawnmower instead of 5. I mean, that's kind of a basic deal of it, but we do apologize, and I just wanted to let you know what was up. Thank you.
Okay, any questions? Okay, and you'll be able to come up for a rebuttal after that.
Thank you so much. Sit over here for a second.
We'll hear from those parties opposed. If you want to come forward, take as many seats as you need. And again, you guys will have 10 minutes to split between the speakers that want to talk.
Hello, my name is Cheryl Cheeves. I'm the opposite side of this. Cheryl Cheeves, 1820 Ashton Avenue. I'm the neighbor and owner of this property and situation. I've never seen these two gentlemen. Today's the first time. I've always talked to the gentleman who told me he was the owner, who is in the back. I've never seen these two that just came up here, ever. I've been dealing with the gentleman in the back, who I thought was the owner, who told me he was the owner, for the past year and a half while they're building this property. I don't have a problem with anybody building property. I had neighbors before they tore the other ones down, and I know I have new neighbors now. I've been in this house 54 years. I've been in this house. This is our family home. I told them from the beginning when they started building this that they was too close. I've been on this street, like I said, 54 years. I pretty much know every yard on this street. We have grew up here. I kept telling them from the get-go, their workers, you're coming too close, you're coming too close. Oh, me fix it, me fix it. This is all I've heard for the past year and a half, going on 2. In the meantime, my meter has been ripped from my property 3 times. I've had to have the electrician, NES, come out there, make them put it back. I have pictures where they have damaged my home. He promised me on several occasions he was going to fix it, never has. I called because they built the property up. Therefore, all the water slopes down on my property now. It's not even. The property's built up. He told me he's going to fix it. It's never got fixed. There never was a drain put in, which is called a French drain. By code, you're supposed to do that to keep the water from coming to my property. That hasn't happened. My mailbox was knocked down. When I came home from a doctor's appointment, they proceeded to tape it back together. It's still got the duct tape on it as we speak today. Like I said, I've never seen these two gentlemen, ever, until now. My other problem is, when I called codes came out there faithfully, told them they had to fix this, fix that. I showed codes. You're only really 4'2". 4'2". It's not no 4 inches. It's almost 8 inches. I have the pictures. They said they'll fix it. It never got fixed. Codes violated them for this reason. Put a work order, stop work order, real big in red, on the garage door. What did their workers continue to do? Keep working on it, getting more and more done to it, sneaking in it when they was not supposed to. I took pictures. I have pictures to show that. I brought it to code's attention again. They again had to come and put another stop work order on this property on December the 9th. to make them quit working on it. They kept wanting to work on it to get it finished, to show you why they need this easement or whatever y'all call it, because I don't know these big words. Why they need this, because they're almost done. Yes, you're almost done now because you took it upon yourselves, your workers, to keep working on it under stop work orders. Do you see what I'm saying? I have no problem with this. You're coming too close to me. I kept telling you that. If you put a fence up now, there's no way they could put a fence up, or I could even put a fence up because of what they have done. He has talked to my younger sister, who is right here. We've had this issue. They promised me they're going to fix my house back. What happens when you rip a weatherhead off a house? You pull the siding off. You pull everything loose. I've got 3 big holes now because I didn't put the weatherhead back where it was supposed to be. They moved it over here. I got 3 big holes. I said, are you going to fix it? I fill it with putty. You hadn't fixed it yet, and thank God you didn't put putty in there. I feel like this is potential gain for his pocket, who I've never seen these 2 gentlemen, for the man in the back who told me he was the owner. I thought that was Aaron Gotta. I've never seen these 2 people ever. I've never seen them step foot on the property. I'm at home all the time because I am disabled. I had to get I'm on oxygen at nighttime. I told him I had to have it fixed each time when you ripped the meter off my house. This is potential gain for his pocket. What he should have done, instead of getting so greedy, put less in there, but you put more to benefit your pocket. Not thinking of my house that you're destroying.
Ma'am, I have a question for you.
Yes.
So the issue that we're looking at here has to do with sort of the proximity and
Yes.
understand here everything you're
Right.
saying has to do with the proximity of this home to yours. If we were to put some sort of condition about vegetation or something, would that alleviate any of the concerns about the closeness of it, or would that impact, affect
I
some of
think
the
that would
privacy
impact it.
in a positive
I
manner?
think it would impact it.
Okay.
Yes, I do.
Okay.
My name is Joni Cheeves. I'm co-owner at 1820 Ashton Avenue. If you did that, the other problem that we're having is when they built that property up, the rainwater now goes underneath our property, and it's damaging the foundation and everything because underneath the house is flooding now. I mean, so putting the vegetation down through there, okay, we don't have a problem with that. But we don't want our house damaged more than, what they've already done. I mean, ripping the weatherhead off the house 3 different times and tearing the siding up, I mean, we have a problem with that.
Understand completely.
But
And
also,
a vegetative buffer, I will add, a vegetative buffer actually could benefit mitigating the impact of runoff
Yep.
as well.
I see some of it, yes. I don't see all of it fixing that situation because now our water meter now is filling up full of water. We've got questioned by the water company. Hey, do you have a leak? No, we don't have a leak. It's because of all the water running over onto our property. So that's something that's got to be fixed as well. And also, something she didn't mention is when in the process of when they were building the house, instead of moving our electrical line, they built the house around our electrical line. Through our electrical line went through their house. They built their house around our electrical line. She lives there. Every time workers will be in there, the lights will be flickering. Honestly, it's a wonder if our house didn't catch on fire from this situation. I mean, and this is what we're having a problem with as well. And then after the weatherhead's gotten...
Ma'am, do you mind handing those photographs to...
Oh, I do not mind at all.
So we can pass them down. Thank you.
And I'm going to ask a question of our codes department while this is happening. It sounds like there's been a lot of complaints by these neighbors to codes, and do we have a record of those?
I'll pull up and see what we've got.
Okay. Because a lot of these issues unfortunately are not before our board. And we
Exactly.
appreciate you coming here, and we did not see any of that in our packet, so we appreciate you coming here. But a lot of these are not in our jurisdiction to fix.
Exactly.
And it would be the codes department. We're just looking at the issue of them building 6 or 8 inches, whatever it is, closer to your home, so.
Right. If they would have built where they were supposed to, we wouldn't be having the problem with, the house flooding and everything. We would not. And then hopefully they wouldn't have been able to rip our weatherhead off our house 3 different times. And I mean, even having wires literally today still hanging from not being put back on properly. And then when they did put the electrical box back on there, it's crooked. And now we have a gap from where our electrical box was that I was told that they were gonna fix, still has not fixed till this day. I mean, everything they damaged on our property, they were gonna fix, has not done at all.
And I would imagine it's important that the codes department know that, and I don't know how they release the use and occupancy to the builder, but, I mean, it can't be released until this is settled at least, but I don't know how your property damage is dealt with. So that will be something our zoning administrator can tell us about.
Okay, thank you.
Ms. Carpenter, I'm showing at least 2 records of a visit by the Building Inspection Division to that property. And you note that first one talks about house built too close to the property line.
Can I speak? Yeah, can I speak?
Yes, you still
Yes,
have
I talked to
some
Mr.
time.
Don Johnson, who works in the codes department. On several occasions, he's even come out and talked to me. He's the one that put the stop work order on it because they kept not in compliance, not working with him. He's even said something that they had to get the water fixed. Well, they ran a drain just from their gutters to the ditch. That doesn't stop the water because your property's up higher now, sloped down, the water coming to me. He told them they needed to fix all this. It hasn't got done. Like I said, the 2 gentlemen just was here. I've never seen them. I'm at that property all day long. I talked to the gentleman in the back who told me he was the owner, and he didn't come up here. So I feel like he told me he was gonna fix everything. Nothing's got fixed. This is to benefit gain to their pocket while you're destroying my home. No, I really oppose of this. I think this is wrong because if you're 4'2" from the property line, your next house is off. Your next house is off. All them houses he's built is off.
Mm-hmm. And there's a picture stating that it's 4'2", 4'3" off, not 5 inches off. So there's they're more than that off. Mm-hmm.
Okay. Is there anything else? I don't see that we have any questions right now from the board members, so. Okay, seeing no questions, we'll call back the appellant, but I would make sure all of this is at codes.
Yes. Okay. Thank you. Thank you.
Thank you.
Thank you, ladies. If the applicant will come back for rebuttal, you'll have 7 minutes and 45 seconds to address the items raised.
Hello, everybody, again. This is Haroon Sultan, the one that she was talking to. He is also an owner of Nashville Quality Homes LLC. It's not an individual, it's a corporation. That's part of the misunderstanding. Also, I appreciate that as a contractor, we're responsible for everything that happens on that job. NES is the one that ripped the weatherhead off her house. NES is the one that fixed it. The stop order was put because of the drainage issue, because they complained about the drainage. We got that fixed. We put in French drains, which are on the plans. Everything's approved. We dug down 2 foot, had to put a gravel bed for the French drains to drain through in order to eliminate some of that. If they think that putting in a mulch bed, something like along the base right there, those last 4.5 feet, we'd be happy to put that in as a consideration. Nothing, we put some smaller plants that wouldn't affect the foundation or anything, like some dwarf nandina or some holly, just something low maintenance that won't grow and take over the yard, just so it wouldn't add any undue burden onto the neighbors. We're willing to do that. But, again, I apologize. We built 18 homes last year, and I can't be everywhere, but this one hurts. We didn't know about this until we submitted the as-built. We had to get another survey. We submit the as-built at the end of construction. We have the surveyor come out at the beginning of construction. We have him come out at the end of construction, and that's when everybody just went, it's painful. I don't know what to tell you. We shouldn't be here. We shouldn't be wasting everybody's time, but stuff like this happens, and all I can do is apologize, and we're sorry. Can I tell you?
Okay, I don't see any questions. Does anyone else have anything to say before we close the public hearing? No? Okay, then we'll close the public.
Sorry, just one quick question. It not our jurisdiction, but it was brought up, so it's part of the public record. I would like to hear what happened between the stop work order. That it seems like first time. So can you briefly talk about?
We're given a stop work order, but then the guy rescinded it and allowed us. He allowed us to get the guys in there to fix the drainage. Once we have the drainage approved, the stop work order was lifted. So it's like, they don't come out and put a big sign on your yard saying stop work order lifted, but when we were given the stop work order, we stopped. When we were allowed to work again, we worked. We just wanted to get rid of this. This has been going on for a while, and it is true that she is there all day. I'll give her that. That was it. But there's a lot of misconstrued blame and stuff, and things that really didn't have anything to do with the setback, and we apologize, but it is construction, and just so you know, not all the houses, it's not a domino effect. This house is over less than a foot, but the distance between the houses is 6 foot, which as they pointed out, which is a foot more than we needed. It's just this one unit. Out of all the units, we got the lucky unit next to her house, and we apologize for that. I'm really sorry.
Okay, we will close the public hearing then, and the board will discuss.
I mean, a 5 or 6 or 7 inch issue is one of those situations where it's a foot being in the wrong place. It's somebody's, hammering the pin in a location that's incorrect. I have an exceptionally hard time tearing down a house over 5 to 7 inches. Which is why I was sort of suggesting the idea of adding some additional vegetation to mitigate against any additional stormwater runoff. I think that the concerns that the opposition has raised are super important in terms of, quality of life concerns, in terms of, the felt and lived experience of living through the construction. A lot of that is just not within the sort of purview of what we consider here. But it does matter and it should matter. And so, we have to look at this as, what are the circumstances that would warrant granting or denial of a variance? And are there conditions that we can place on it to mitigate against, any potential impact on neighboring properties? I mean, in my view, that mitigation would be some sort of vegetative or landscaping buffer. But
That makes sense. I would say the Metro Stormwater Department should vet through that and see what the proper remedy is, rather than us, our board. Yeah, it's, because stormwater is so complicated, as you know.
right, yeah, oh yeah, yeah.
I was just gonna say that I typically would agree with you, Mr. Bradford. Like, I think your sentiment is totally right. I think where I'm a little stuck on this is that, like, one thing I do know, especially as Nashville has grown and built, like, every inch kind of matters, right? So even though it's not that it's feasibly not that big, it seems like to the neighboring property owner, who we do have here, they're saying it does injure them. And so, and given a lot of the stuff, you're right, it's outside of our purview. We don't weigh into that. We don't have jurisdiction. A lot of the stuff that they outlined would go to General Sessions Court or Circuit Court. So that's the proper place to go with all of this stuff. Our question is just whether or not a variance should be given. And one of the things that we always look at is if it's injurious to the neighboring property. And here, I think there was testimony that it is. I'm not talking about the weather vane and all the other stuff, like, that's contested. I'm just looking at, these houses are pretty close together. Every inch probably matters when you're gonna build something that close to the property line. And we do have testimony that it has injured them. And so I think that you're right, and I think that that's normally prudent. I just have a hard time kind of getting there on this particular case, given A, how close it is, and then B, the testimony of the neighbor saying, hey, this is injuring me. So that's all I have.
And I agree with you that I think there's been a statement of that injury, and I think, we have to take that for what it is. And so that's kind of where my head has gone, in terms of, is there a condition that can essentially mitigate against what that injury is? I mean, I'm not a stormwater runoff. I've had some experience with French drains in my prior professional life, and I know that those are effective, but to the extent there may be some sort of additional thing that can be done that can help mitigate against the impact of that runoff, to the extent that it is damaging the neighbor's property with flooding, basement flooding or anything like that. To the extent that the closer proximity creates an issue with roof line runoff in some way, shape, or form, and there's a way to handle it through routing those.
And I think that's the hard part too, because typically when we put a condition, normally within our experience, we can say this condition will help with this. I think because of the complexity of what they've presented, I don't feel like I have the expertise to say this will help with the stuff that they've outlined. I think somebody else is going to have to give us that. So I agree with you. I just want you to know that. It's just that this one's a little harder for me, because I don't feel like I have the expertise to say vegetation or this sort of, I know that they put in a French drain, and I do believe that the applicant had good intentions, and I think they were super contrite, which I really appreciate. I do want to say that. I do think the applicant is very contrite. I just think that this is a hard one, and that I think people who are way smarter than I should probably help craft the solution here.
I have it's outside of our jurisdiction, but solve this problem among two neighbors. I think it would be good to two of the neighbors, property owners, to sit down, the best solution to give them quality of life and mitigate runoff into their neighboring property. And I think this public hearing would give them those opportunity. So I think that's the solution. But as far as, 6-inch, yes, to enforce that strictly will be kind of harsh punishment. So I'm not really, into that. So I totally agree with you with, Mr. Bradford for that suggestion, 6 inch. But I think something need to be done. So landscaping buffer might be the best, but they may not be, resolve the solution. So I think they need to sit down and come up with solution both can agree on. So that would be my suggestion.
So taking what Ms. Johnson and Ms. Davis have said, and this is, what if we were to defer this case to allow submission of some sort of additional, either landscaping or stormwater consulted approved plan, come back to us with some of the things that, as Ms. Davis aptly put, people much smarter than I can pull together.
I'm gonna say they have different expertise than we do.
Yeah, yes. So I don't even know if it'd be feasible to have somebody from Stormwater come to meet, or just getting the, some information.
I think we should have the applicant meet with the stormwater department and come up with a solution that will work. And I'm sorry, the public hearing is closed. We can't take any comments.
Yeah, sorry that we're.
And just one thing I was gonna add was, if the solution is to tear down the wall and build it back 6 to 8 inches, then I think the neighbor will be still continuing to go through some construction hassles that have greatly impacted her life. So there's that to consider too. But did you have a motion? It sounded like you were.
Oh, let's see. Sure, let's give it a shot here. I will move that we defer this matter 2 meetings to March 6th with a request to the applicant to confer with the Metro Stormwater Department and submit additional information regarding additional stormwater runoff mitigation, including without limitation, landscaping or other, structural or non-structural measures to present to the board for consideration.
I'll second that. There's a motion and a second. Any discussion on the motion? Okay, all in favor say aye, raise your hand, aye. So there's 4 in favor and 0 against.
Okay, that case is deferred till March 6th with the condition as stated. I do. Yes, ma'am, I do. Those are what you submitted? Yes. Yeah, I've got those. Thank you.
Thank you so much.
All right. Our next case 2025-008, Cynthia Kennan, appellant and owner of the property at 401 Parker Court, requesting a variance in the side street setbacks in RS10. The appellant constructed a deck without a permit, seeking to construct a roof over said existing deck, referred to the board under section 1712.040 and 1712.060. The appellant has alleged jurisdiction under section 1740.180, item B. Is the applicant present? All right, miss, come forward. Is there any opposition present to this case? Okay, seeing no opposition, you'll have 5 minutes to present your case, and let me go through the photographs and such, like you've seen in the other cases. And reset this clock over here. Okay. Let's see. Right. Okay, the subject property you see is located, the parcel down in red, and the area at issue, you can actually see it best on this aerial photo, and I'll pull up a different one too, is right here. When Miss Kennon's house was issued a building permit, at the time of the permit issuance, I was just pulling up the site plans and drawings for the applicant. The builder was issued a permit with a patio. I don't know if you can see that there. And somewhere between this building permit being issued for a patio, which is allowed in the street setback, a deck occurred. So I don't have the precise time. When we look back at aerial photographs, one aerial shows the land during grading, the next one shows it constructed with the deck. So I presume it's going to be, I'll show you that aerial. Yeah, so this is the aerial in March of 23, brand new neighborhood. And then March of 22, her particular lot, I think, was a staging area for some of the other homes that were being built at the time. So I don't have kind of an in-between. So at some point before or prior to UNO, the deck was put on. How it came to our attention was I had actually met with this neighbor. I was wanting to do something similar to get a building permit. You see their little concrete pad sitting approximately same location. And we had turned down a request and kind of brought it in like, hey, wait a minute, there's one right here. So long story short, we ended up going to the B's. I think the house next door to you went to the zoning board to enclose the deck on the back. And at that time, I was like, yeah, this is definitely here. So it's kind of precipitated Miss Kennon's case before you today. But I think, too, there was a permit request to cover that deck. And that's kind of what sort of triggered everything. Like, wait a minute, how'd that deck get there? Don't know, but obviously I'm not going to completely blame the appellant in that case. That the builder may have done that at somebody's request, but it's been known to happen. But long story short, concrete patio is fine. Decks, since it's above grade, is subject to the street setback, and obviously if we cover it. So in order for Ms. Kennon to proceed with any sort of construction permit to cover that, we'll have to get a variance for the entirety of the structure. But this is, there you go. This view of Ms. Kennon's house when I went and visited on the 28th. You see the deck right there. Very nice structure.
Joey, does there, and I don't know what the status is on one of those bills or one of the pieces of legislation that was coming about allowing porches or things to encroach. How does that intersect with this at all?
It doesn't intersect. We do allow covered porches. That bill did pass to allow covered porch encroachment into a street setback, not more than 6 feet. And I think the size of this is beyond 6 feet, if I recall. Roughly.
Looks like it's 10.
10 feet, yeah. So 4 feet of this is essentially the variance you're talking about. It's a 4-foot portion of that structure would need the variance. The council bill that passed that ordinance still required a minimum 10-foot setback from the right-of-way for any kind of covered structures.
Okay. So that means that this would, yeah, okay.
Yeah, so the portion the board would be dealing with not 6 feet of it's fine, no problem. We'll issue a permit for that. It's the additional 4 foot to cover the remaining 4 foot of that deck. And no, thanks for bringing that up. And then just a bit of a comment on we talked about our last fence case. This is an open fence that you see here. This wrought iron kind of fence, that's an open fence, which is allowed to be to the property line. Which, given we do have a survey on that one, we know where the property lines are out here. So, and it's a brand new subdivision, so it hasn't had time to fully mature and create zoning violations yet. So, but that's the case record we have it, Ms. Kennon. You've got 5 minutes to present your case to the board.
My name is Santia Kennon. I live at 401 Parker Court in Antioch, Tennessee. So I purchased this home in 2022, December. And of course, it's a new build. So I had a change of order addendum to the new home purchase agreement because of the elevation the land sloping to the ground. And this is considered like my backyard, the way the house is constructed. So instead of doing the patio, this is why the deck was constructed. So I have the grade order for this. And like you said, there was a permit submitted by the construction company that built the home, saying that they were going to build the deck. The property, the deck is not over an easement, so there's no issue with the sewer. I did apply for that, and they said that everything was fine on that end. So my biggest thing is, like, this will allow me access out from my patio doors to my yard, and, you know, have pets. And if the deck is taken away, then I'll have to do a whole new construction with trying to get access to my yard. So it's kind of like inconvenience. And like I said, this was done in December 2022, and there was a final U&O done, and it wasn't an issue at the time. You know, they said the house was livable, and I moved in, and it wasn't an issue until I applied to have the deck covered and was told that I didn't have a permit to have the deck in the first place. So I just don't understand how all this occurred. It was not an error on my end.
So you said the deck was there when the UNO was issued?
Yes.
Okay. Looking to see if there's any other questions. Okay, doesn't appear there are any. Is there anything else you'd like to add?
No.
Okay, thank you. So we'll close the public hearing and discuss.
This is not part of our consideration. It is a very nice looking deck. The slope of the property, I think, we have testimony that there is a justification to have an elevated deck rather than a patio poured to grade that meets the standard of granting a variance. So I make a motion that we approve the variance for the deck as requested.
Agree. I think we are only extending 4 foot because up to 6 feet is allowed to
correct.
encroach within
Yes.
the variance. So the amount is 4 feet. That is kind of important.
Right.
Not 10 feet.
I just want to make sure I understand your motion. So it's for the deck and covering it, like the 4 feet over? Is that what you're at?
Yeah, yes.
She's asking.
It's to approve that.
Okay,
Yes.
I just want to make sure.
Okay, I heard a motion. I don't know if I heard a second.
A second.
Second? Okay, there's a motion, there's a second. Any further discussion? All in favor, say aye, raise your hand. Aye. So 4 in favor, 0 against, so it's approved.
Thank you.
You're welcome. We'll take a short break.
Okay, the board will be in recess for a few minutes, and we'll be right back. Nashville Network. We'll go and give you the thumbs up. We're about to get started again. Okay. Okay, the next case on our agenda is case, at the bottom of page 2, case 2025-009. Mohammed Qureshi, the appellant owner of the property at 5047 Seymour Hollow Road, requesting a special exception to allow for a kennel in the AR2A district. The appellant was seeking to train dogs on the premises. Referred to the board under section 1716-175, the appellant has alleged board would have jurisdiction under section 1740-180, item C. Let me pull up the members. You don't get a lot of kennels, so let me cover a couple things in the zoning code definition of kennels. Kennels and stables are lumped together for some reason. Kennels are not, let me say this, kennels can be doggy daycares as well, but the definition, our definition's fairly old in nature. It envisioned your breeder, that bred show dogs or that raised animals, but it was amended over the years to include things like dog training, and they lumped horses in there for some reason. But anyway, it's kind of all encompassing. But let me read to you just real briefly the definition. It says, any lot or building structure or premises used for the boarding, breeding, training, and or raising of domestic animals and wildlife, excluding livestock, so not your farm animals, referred, whether by owners of such animals or by persons providing facilities and care, whether or not for compensation. We've had that in the past. Well, I don't charge anybody. I do this for free. It doesn't matter. But shall not apply to the keeping of animals in a municipal pound, pet store, or bona fide laboratory for experimentation purposes. Yikes. But anyway, or veterinarians who were boarding patients. So historically for us, vets were always allowed to board your animals, whether they were being treated or, hey, you're going out of town. Before the rise of doggy daycares, we'd allow vets to keep animals as an accessory use. As doggy daycares have come about, we put them under kennel. You've seen several of those. There's one in Dawson recently you approved near McDonald's over there in Hermitage. They're in CS districts. They'll come to this board for approval. But this particular gentleman inquired to our office, I think, about training of animals. I don't recall the specifics of it, but the training or boarding of these animals. And we mentioned to them then that they would have to come to the Board of Zoning Appeals and seek an approval as a special exception. The criteria for special exceptions are laid out in section 1716-175 of the code. Not all of this, as I mentioned, horses are also lumped into that, so many of the conditions listed in the zoning code are not applicable when it comes to dogs, but I'll read briefly the ones that are applicable. Setbacks talk about no building structure or in which the animals are housed shall be closer than 200 feet, and no kennel runs are located within 100 feet of any existing residences other than the one owned by the operator or owner. In the event that more than that's horses, we'll skip through that. Enclosures must be provided that allow adequate protection against weather extremes. The floors of such buildings, runs, or walls shall be made of an impervious material to permit proper cleaning and disinfection. If there are cages used, each animal shall have sufficient space to stand up, lie down, turn around without touching the sides of the cages. Cages are to be a material and construction that permits cleaning and sanitizing. Floors shall be made of concrete unless radiantly heated, and shall have a resting board of some type for bedding. For kennels on runs, each run must have at least a 6-foot-high fence completely surrounding the fences, must be maintained in an escape-proof condition. Run shall provide adequate exercise area and protection from the weather. All animals quartered and runs are to be kept clean and in a sanitary condition. The next 3 conditions deal with horses exclusively. And then item 8, all gates or entrances into the, for stalls, it's also horses, so I apologize. 9 talks about the watering of animals. Water vessels shall be mounted or secured in a manner that prevents tipping over and shall be of the removable type. And then on-site waste collection, all on-site waste shall be housed either within the kennel building or an accessory structure, and all waste shall be disposed of in a sanitary fashion no less frequently than 1 time per week. It lists some other items that appear to be horse-related. But the subject property is, if I can get my presentation to come up. Here we go. Subject property you see is located, it's a large tract located, the red parcel is the Seymour Hollow Road runs east to west off of Clarksville Pike, which is the, Clarksville Pike's the north-south arterial that you see where my cursor follows. Seymour Hollow Road runs perpendicular to the appellant's property, then jogs north and then continues to the west. Before you, I passed out a black and white copy, but this is the map used with our GIS to show the distances of the proposed kennel area to the nearest residences. And zooming in a little bit so you can see those distances. And then my view of the property upon my visit on 29th of January. These views are from the Seymour Hollow Road facing north into the site. The proposed structure that's proposed to be used, I believe, is that structure there. I'll let the applicant discuss that. I did not go up into the property. As advised by council, we tend to not trespass on people's property like we used to a long time ago. You didn't hear that. Years ago, I'd go in your backyard and take pictures of the site. I don't do that anymore. So, but anyway, that is the case records. We have it. There's opposition present, I believe. Show of hands. Thank you. Okay. Each side will have 10 minutes to present your side of the case. Again, like we talked about for all parties present, the 3 of y'all, as the appellants, you'll have 10 minutes. Opposition, you'll have 10 minutes. You know, if there's multiple folks that want to come talk, y'all work out who's coming and for how long you'd like to speak. And with that,
Joey,
I'll turn it over to...
Before give time to the applicant, could I ask one definition clearance?
Yes, ma'am.
This is under kennel, and there's also Metro has animal boarding. Mm-hmm. So this business is under animal kennel. So if you would briefly say difference between boarding and kennel.
The difference is I'll tell you this, council member, and I've been telling, and I say you guys this, the former council people and current council people, there's not a ton of difference in the definitions, but the intent of animal boarding facility was intended to be used for public or private nonprofit entities like the Nashville Humane Society, the Animal Pound, the animal control facilities that Metro operates, the public facilities, or private rescue facilities that may keep dogs. We put those under animal boarding facility, and then we leave the kennel/stable for private operators, doggy daycares, and that sort of thing. I would love for the council to revisit, whether it's this council or a future council, to revisit all of our animal definitions, and let's get them a little cleaner and clearer. I've had to, as I've talked about in my job as zoning administrator, sort of live in the gray between the black and white parts of the book and figure out, okay, what works, where, and so that's kind of what we've come up with is animal boarding facility. This does not fall under that. It's intended for those public or private entities that either do dog rescue and that sort. And when you look at the land use chart, those types of uses are more industrial in nature in the land use chart, not in residential settings, whereas kennel and /stable, as you see in the zoning code, is And all the districts are permitted by special exception, meaning they have to come here to seek approval, whether they be in agricultural zoning like this one or in residential or commercial zones. So that's the difference between the two. Some would argue it's a difference without a distinction, but that's how we distinguish
So
between.
with that vague definition, if this training involved like overnight stay or a couple, 3, week of boarding in the facility, but still under the kennel category? Yes. Okay, thank you.
Okay, with that, I'll turn it over to the applicants. If you would, please identify yourselves and make a presentation to the board. Again, Counselor, you'll have a period for rebuttal should you wish to save some of your 10 minutes.
I would. I think we'd actually like to save 7 minutes of time for our rebuttal. My name is Jason Holloman, 4210 Park Avenue. I'm an attorney here in Nashville on behalf of the applicant, and I do want the applicants to just introduce themselves, and particularly want to ask Mr. Qureshi to identify a little bit about his background with law enforcement and with dog handling. So go ahead.
Thanks for the opportunity. Happy to be here. My name is Mohammed Qureshi, and I live at 5047 Seymour Hollow Road, Whites Creek. I came to this country when I was 20 years old to support my old mom and dad, and worked about 3 years for almost 3 jobs to support them. And once my family was in good position, I wanted to thank this country and have that dignity to give my precious youth and time and join the Marines. In the Marines, I was deployed to Iraq and served in combat zone. And I was a combat engineer and a martial art instructor. I was honorably discharged from the Marines and joined the police department in New York, and served about 18 and a half or almost like 19 years as a police officer without any civilian complaints. The reason I became a cop to help people and leave the people in better condition when they call 911. I never had any CCRB complaints, and close to my retirement, I fell in love with dogs and wanted to help them and train them and help people to better understand. I went to college. I went to a lot of certification courses, traveled around the country, learned from the best about dog training. Then canine training sparked my interest, and I went to canine training school. And since then, I've been training dogs for police department, and I decided to open up my security business, security company, armed guard, unarmed guard, and canine security for explosive detection. I was a part of intelligence department in NYPD, and I was deep undercover, where I was kind of close to dealing with terrorist group. So when I came to Nashville, and I wanted to expand on my explosive detection canine part of the company, and I decided to buy some land and pursue that dream.
Thank you. Just introduce yourself for the record.
I'm Rossi Qureshi. I also live at 5047 Seymour Hollow Road, and I'm Mohammed's wife.
Thank you. And members of the board, I do just want to be clear, particularly in light of Councilmember Johnson's question, which is that we are really only here because within the definition of kenneling includes training, and this is not even primarily a training facility. It is really to house working dogs that are part of Mr. Qureshi's business. Most training actually will occur off-site even. These are dogs that are specialized to sniff out bombs, drugs, and guns. And he does that on a contract basis at various locations around the country. And this is just the facility adjacent to his home that is going to house that. In an abundance of caution, he has to get clearance from ATF. We thought it was appropriate to come and get this permit. We have had our community meeting. The notices were sent out. The meeting was held on the 27th of January at the Jolton Community Hall. You should have information in your packet about the letter that was sent to adjacent property owners, as well as the sign-in sheet from that meeting. And I do want to note, just to reiterate, we are the primary, logistical issue that we have to overcome is that the facility will be 200 feet from any other home. We are more than 300 feet from the two nearest homes. We meet that. We certainly plan, as this is completed, to comply with all of the cleanliness requirements, the runs, the stalls, certainly plan to comply with all of those. So with that, I'll just reserve the balance of my time and answer any questions.
Yes, I have a question about the run. I think what our information only state a location of the stable or housing of the place, kennel. Is there any plan for the dog run? And if so, what's the plan for fencing around it to keep the dog secure?
Do you want to respond? I mean, yes, we plan to have fenced-in dog runs. That's just not constructed at this point. And we plan to comply, obviously, with the code requirement for that.
Would a plan be available?
Yes, I mean, I would presume that there would be a follow-up inspection by the zoning administrator before the facility is complete to confirm that all of those guidelines are met.
Okay.
District Council showed up to the meeting, and we discussed the fencing plan. And we drew up a fencing plan and emailed that to her. And also I emailed the fencing plan to the planning, and Mr. Paulson, Christopher, received that email, and he spoke with Miss Dana, supervisor, manager, and they said that you're clear on our side, and you don't right now need the fencing plan from our side. But the fencing plan was sent to Mr. Paulson.
Okay, unfortunately, the board packet I have does not have any of the plans or really much of anything, actually. We just have your word that you will be intending to comply. And I think, for me, I feel like we're here, we have to make sure you're going to comply with these things, and we need to see a plan. And unless I missed it, I don't have this information.
Okay, they do have a written plan that my understanding was submitted. We're happy to, can you access the drawing that you have? Yeah, we'll send that to you right now.
You can keep going while we're waiting on that. If you have anything.
We can send that to you, and then when the opposition goes, we'll certainly answer any questions about it.
Sure, on the rebuttal, we can ask you some questions if you
Right.
want. Yep. Do you have anything else before the opposition comes up?
No.
Okay.
Okay. Thank you. We'll get that to Joey, and then.
Okay, members, we'll reset the time clock, and we'll have those parties opposed to the case if they'll come forward. Got 4 seats there. Guys, careful with the microphones a little bit, but when you're ready to speak, just push that button just to the right of the microphone stand, and the light will come on, and identify yourself and name and address, and then present your testimony to the board.
Good afternoon, Mr. Hargis and members of the board. My name is Zach Runquist, and I live at 5080 Seymour Hollow Road. On behalf of my family, neighbors, and those that wanted to come out but were unable, thank you for your time. I have some videos to play in a moment. The first 2 have audio. I'm not sure if we'll be able to hear that audio or not, but Mr. Hargis has that. So this is, just watch along, please. I trust that all zoning board members have received our letters in opposition, of which there are 9 letters representing 8 households. Our neighbors in opposition who sent in letters and could not be with us today due to work or sickness are Lisa Benson, 5016, Chad Johnson, 5028, Chemo and Danielle Forrest, 5072, and Gary and Joyce Stenberg, 5043, who are out of town. Mr. Jason Mooneyhan, 5124, did not receive a letter from the zoning board, and Mrs. David Gunnerson, 5076, has been in the hospital the last couple of weeks, but sent a letter in. I was born and raised at the dead end of Seymour Hollow Road. My wife and I recently bought a house in 5 acres last August at 5080 Seymour Hollow Road. We were looking forward to the peaceful sanctuary this road has always been. My first interaction with Mr. Qureshi was shortly after we purchased the property. He was walking several German Shepherds off leash and said, "Welcome to the neighborhood," and then threw a ball into my yard for them to retrieve. The second interaction was on September 27th, 2024. I looked out the back window of my house and saw him trespassing with 3 German Shepherds and a Husky, approximately 200 feet deep into my property. He appeared to be taking pictures. 2 shepherds were off leash. I went out the front door and around the side of the house and said, "Hey." Before I could get any more words out, the 2 off leash shepherds immediately charged me, driving me up on the side porch with Mr. Qureshi being approximately 100 feet away and out of sight. I immediately drew my concealed handgun and yelled that I would shoot the dogs. All of this happened in a few seconds. He yelled at the dogs, but they continued to press in. He tried to gain control of them verbally with little effect and said, "Put the gun away, they won't bite." Since the side porch wooden door was locked, I had to retreat between that and the glass storm door. He eventually got all the dogs on a leash and said, "Sorry, I didn't know you were home." I told him this was private property, and he left with the dogs. I immediately called the police and animal control. Out of 24 years of legal concealed carry, I've never had to draw my weapon out of fear of loss of life or limb. The third interaction, October 23rd, 2024, I was cutting a tree in my yard roughly 120 feet from the county road. Mr. Qureshi walked by with 4 dogs. 2 off-leash German Shepherds and 1 German Shepherd that was dragging a leash wandered into my yard. After telling him to get his dogs out of my yard, he yelled, "Stop being so petty, stop being so petty. Their paws aren't going to damage your yard. Have some class. Stop being an a-hole." Video provided, that was the video you first saw. It has audio that Mr. Hargis has. The physical and emotional well-being of our residents is at stake. Fear of dogs instilled in children, adults, and seniors by these charging incidents will last a lifetime. Many residents have stopped utilizing the road out of fear of being charged, bitten, or worse. My wife and children are afraid to walk or ride their bikes down the road, walk to the mailbox, or take our own 2 small dogs into our own yard due to the aggressive nature of Mr. Qureshi's dogs. His dogs have already chased our cat as well. Being charged by multiple dogs could lead to a heart attack for any adult, but especially for our elderly, like my 77-year-old mother, a cancer survivor who walks the road almost every day. In response to the leash letters and running at large notices, he's been sent 3 or more. Mr. Qureshi lets some of the dogs drag their leashes as they run at large. Mr. Qureshi states he is a Marine and a retired police officer. Service to our country holds individuals to a higher standard of public trust and doesn't grant them special permission to disregard the law, trespass on private property, or use other land as his own. He can be seen regularly doing each. Mr. Qureshi states in his letter that he believes his business will actually enhance the security of our neighborhood. The neighborhood has experienced the exact opposite. Residents have to deal with daily anxiety and fear of him and his dogs trespassing on our property, being charged or bitten while walking the public road, or charging, chasing, and worse for our livestock and pets. Mr. Qureshi has further demonstrated his disregard for Davidson County leash laws after multiple dog charging incidents and being sent multiple letters by Metro Animal Control. As he states in his letter, he plans to train bomb and drug dogs. This will require the procurement of bomb-making materials and ingredients as well as narcotics, neither of which belong in a residential environment, nor in the hands of someone that disregards the law. I urge you to immediately do your part regarding this special exception permit, and please help protect this formerly peaceful sanctuary of a neighborhood. We do not want this forced on us. Please deny this request for a dog kennel on Seymour Hollow Road. I also have letters if you guys, from all the neighborhood, if you guys would like a copy of those. I believe so, yes, sir.
Good afternoon. My name is Cheryl Runquist. My husband, George, and I live at 5131 Seymour Hollow Road. We've lived in the same house for the last 50 years and have raised our sons there. Seymour Hollow is a quiet, one-lane, dead-end road and residential, about 12 houses. Everyone knows their neighbor. There are families with children ranging in age from toddlers and elementary age to teenagers, and there are seniors who have lived there longer than we have. There are also adult children of former residents who have passed away who have returned to Seymour Hollow to live here once again. It's peaceful and pleasant, and many of our neighbors, as well as myself, walk on the road most every day. I continue to do so, but there are fewer and fewer of my neighbors who venture out since Mr. Qureshi moved in with his dogs last January. On March 21st, 2024, I was charged by one of Mr. Qureshi's German Shepherds barking and snarling off leash when I was walking. It's truly startling, nerve-wracking. Mr. Qureshi's adult daughter, who was behind the dog several feet, struggled to get the dog on leash, under control, and removed from the area. The dog would not heed her verbal commands to stop or come. I texted Mr. Qureshi the next day to ask if his dogs were locked up so I could walk on the road. It was only then that he apologized for his dog aggressively charging me. Beginning in April, when I wanted to walk, I'd start texting Mr. Qureshi, just ask him if his dogs are locked up so I could walk. And that lasted for a couple of months. That worked. But in August, I texted him and there was no response. August 7th, I texted him again, no response. I went for a walk and was charged again by one of Mr. Qureshi's German Shepherds. This time, the dog barreled toward me at full run from over 100 feet away, barking and snarling, and did not stop. There was no owner or handler inside, and it was a frightening experience, and I was almost paralyzed with the thought of being attacked. There was nowhere to hide, and I knew that if I bolted, I would easily be overcome by a dog who weighed almost as I do. So I stood my ground, held out a billy club horizontally that I'd recently purchased because sticks break, and pushed towards the dog's head as it continued to bark and snarl while circling me. We both were going around in a circle and made at least 2 revolutions. The dog was in a crouch and facing me during this incident, not just running around me. Out of the corner of my eye, I saw that Mr. Qureshi's adult daughter was approaching, and she eventually secured the dog on leash, dragged him away. She said nothing. I remained bent over in the road, leaning on the nightstick and regaining my breath and composure. The daughter never returned to see if I was okay, nor apologized. I reported the incident to Metro Animal Control, and they promptly sent Mr. Qureshi a letter telling him that a complaint had been filed against him and his dogs for running at large. The letter informed him that he had violated Tennessee codes, and he was told to keep his dogs on leash under physical control at all times going forward. Mr. Qureshi's response to receiving the letter from MAC citing Tennessee code was to attach leashes to his dog sometimes, but to let them drag the ground behind the dog. Going forward from this date, which was mid-August, when he had his dogs out, sometimes 5 at a time, his husky and mixed breed dog might be on leash, but if leashes were on the 3 German Shepherds, they'd be dragging the ground behind the dogs. His dogs are out and off his property every day. November 15th was my last confrontation with Mr. Qureshi and his dogs. Seymour Hollow Road is an east-west road, and the houses are on the north and south side. I was heading west towards my house and was in front of the Rincon's house, 5027, who lived 2 doors to the east of Mr. Qureshi. I spotted Mr. Qureshi's 5 dogs, all dragging their leashes and heading for their own house, coming from the south side of the road, having been loose on Mr. Michael's property, 5050, directly across the road from Mr. Qureshi. I slowed down, hoping the dogs would not spot me. Mr. Qureshi was behind the dogs, and he soon appeared. As soon as I saw Mr. Qureshi, one of the dogs dragging his leash, a mixed breed, bolted and ran in my direction, plopping down in the yard of the Stenbergs, 5043. When the mixed breed dog bolted from the group, a German Shepherd, which might have been a Belgian Malinois, also left the group, dragging the leash behind. The dog knew it was free, spotted me, and began to approach. The dog was not barking, was not charging, but I did not know what the dog would do. I didn't know the dog. Mr. Qureshi was about 10 feet behind of the end of the dragging leash, but he made no attempt to pick up the end of the leash was dragging and stop the dog from advancing towards me. I asked Mr. Qureshi to, quote, pick up the leash, Manny, unquote. He did not. I asked him a second time, more forcefully, to pick up the leash, but he did not make a move towards the leash. I noticed then that he was smirking, seeming to enjoy watching, making me more uncomfortable. As I yelled the third time, even more forcefully, for him to pick up the leash, I pulled my weapon, keeping it pointed at the ground, and it was only then that he made movement to grab the end of the leash. I've been a legal, permitted carry holder for almost 30 years. And that was the first time I've ever had to pull my weapon to defend myself in what I believe to be a life-threatening situation. It was a heated moment. I asked him, why would you not pick up the leash as I requested? Were you intentionally trying to have the police called on you again? He angrily responded, "Call the police, I don't care, I don't care." It was at that moment that I came to the conclusion that Mr. Cressy was acting like a bully. This past Thanksgiving night was a dark night, no moon. There are no street lights in our small valley. My husband and I were returning about 9:30 from spending the day with other members of our family. When we turned onto our own road from Whites Creek Park, our headlights lit up the road. Directly before we came to the Rincon's house, 5027, our headlights caught 3 German Shepherds in the Rincon's yard. Our immediate thought was that Mr. Qureshi's dogs had somehow escaped, but within moments, Mr. Qureshi appeared from the house side of the yard behind them. He was dressed in black from head to toe and waved us on and away. You will notice in Mr. Qureshi's letter to his neighbors concerning his business plan, which was enclosed in the Zoning Board Appeals mail-out letter, he states that, quote, all training activities will be conducted.
Ma'am, I'm sorry, the time has run out.
I forgot.
But thank you for your testimony. We do have 2 other people who would like to speak.
I'm sorry, I can't hear you.
Yeah, 2 other people that would like to speak. And if I can ask you all, do you have different testimony, something different? Or is your testimony the similar about the dogs being loose?
I would like to make a comment. We've lived there for 50 years.
Can I get your name?
My name is George Lundquist.
Please?
I live at 51.
I'm going to give you 30 seconds, if that's okay with the rest of the members. Okay, 30 seconds.
My name is George Lundquist. I live at 5131 Seymour Hollow Road. We've lived there for 50 years. And over these 50 years, we've had dogs up and down our road. And we've never had a problem with dogs until Mr. Keshi moved in with his German Shepherds. And we violently oppose the dog training facility. I don't believe that he has, if he's not going to train, he is training the dogs now on our roads and on private property. And so I don't think he's not abided by the laws that are already here. And I don't see any reason that he's going to in the future. And that is my contention, and that's why I think it should be denied.
Thank you. And I'm going to ask the board members, if you all will stay there, if the board members have any questions for you all. No? Okay, there's no questions, so we'll call back up the appellant. And we should give the appellant 30 more seconds.
Well, yes, ma'am.
Thank you, members of the commission, or the board, I'm sorry. We did share with Mr. Hargis, which I hope you have now, drawings to demonstrate. It's not just going to be a run. There's going to actually be an entire closed area for the dogs to exercise. It's much more than a run. But these are the construction plans, all of which do comply with the requirements for special exception for a kennel. I do want to reiterate that this is not a dog training facility. These are trained dogs. They are working dogs that work in bomb detection, gun detection, and they are simply on site because this is his personal residence and he keeps them there. He's building the kennel to have a separate facility for them. In terms of the things that were said, I think the best way for us to handle that is just to say that we vociferously disagree with that account, and that Mr. Qureshi has received no violations from Metro Animal Control, and in fact has received no contact from Metro Animal Control, when we didn't see any documented information to contradict that. So certainly if there are questions, we'll be happy to answer those.
Yes, I have a question. Now, how many dogs will be housed on your property? Is it more than, how many do you have now?
Right now, there's one who was dumped on us, and she was abandoned, so she showed up to our neighbor's doorstep, and for some reason she couldn't take care of that dog. So we took her to Metro Animal Care Control, and they were swamped with so many dogs, so they asked us if we can foster the dog, and we said sure we could. And then
she's your pet?
No, we were a foster field.
How many do you have total?
Total now, I have 5 dogs.
5 dogs.
2 of them are canine, One is Belgian Malinois, who's explosive detection. One is German Shepherd, who's firearm detection dog. And another one is in training to be firearm and explosive detection dog. And when we have Husky, we have him for a long time. He's about 6 years old. Yes.
And once this fence is built, is the intent to keep them in the fence at all times?
Yes, ma'am.
Okay, so they won't be wandering on the road?
They're not really wandering. They always have leash and they always drag leash, and they're trained to stay with me at all time when I'm walking with them. And
I
yes.
don't know the leash laws for Nashville, but
The
I
Metro
would think
Animal
you have to hold the leash.
The Metro Animal Code actually allows you to be under voice command or leash command. Joey can probably verify that, but
Yeah.
if you are a trained dog, you can be under voice command.
He's right, but I will say that, like, I really appreciate the testimony, but the videos are not great. I'm just gonna go ahead and be honest with you. Those videos are not great. And so we have conflicting testimony, and we'll have to resolve that in our discussion. But you are right, because I'm familiar with that code. You and Mr. Bradford agreed, they can be under voice control or leash.
Okay.
But I will say that is also part of the point of constructing the kennel, is to have a workout space that is fully enclosed. I do also, if you can just introduce yourself. This is the nearest neighbor. So when you look at the chart, the homeowner that is the nearest is with us in support.
My name is Mark Hollings. I live at 5057. I'm directly next door to them. I own 3 parcels of land, 25 acres that completely cover one side of them and the back of their property. And I have also given them permission to throw the ball, train the dogs, exercise the dogs in my backyard also. And I have no opposition for this, and I don't see any increased danger to the neighborhood through my eyes. And I guess I would think a security company with police dogs and bomb dogs would bring more security to the neighborhood also.
Okay, do you all have anything to add?
I'd like to add something. During Mrs. Runquist's testimony, she stated that there's one occasion that she pulled a firearm at my husband and the dog. That's not the only occasion. I have 2 daughters, both have their security guard license. They're both in training. They've both been actively involved with our canine business for several years. On one occasion, the girls were actually walking the dogs on the leash, and she pulled a gun out at my daughters and was yelling at them that they don't have control over the dogs, and they were terrified, right? The only reason that I didn't involve police, wanting to be mindful, I know she has recently recovered from cancer. I'd lost my mum to a very aggressive brain tumour, and I didn't want to inflict that pain of her having to go through any kind of being arrested, or just wanted to keep the peace of the street. Post that situation with her, I had actually asked my husband to reach out to her to try to resolve any issues that we had. We've offered several times for her to come and actually meet the dogs, let the dogs meet you. The dogs are going to bark at someone if she's carrying a gun, right? And then she pulls that gun out. That's when the dog barked at her, when she had the gun out. I understand, you're looking at that. There are dogs all over the street, and Mark can attest to that. There have been dogs all over Seymour Hollow Road. We are the only ones that actually walk our dog or have a leash on our dog. Nobody else on the block has their dogs on leash.
I also want to add something to her son. I don't know his name, Zach. Yeah. I didn't know that he bought the property. And I was walking my dog in the creek, and I was coming up, and that house that he bought, it was abandoned for a long time. And me being a good neighbor, or coming from that New York mentality to keep an eye on these abandoned houses, that's where all the burglars and squatters start to settle in and bringing down the safety and quality of the neighborhood. Just for that purpose, I always keep an eye on these houses, and I had no idea that he bought the property. So when I came up, he came out screaming, yelling, and cursing with a gun in his hand, and it startled one of my dog. And then this was the dog's response. When he saw the firearm, he barked, and I called him back, and I said, sorry, sir, I apologize that I didn't know that you were here. I will never come back here. And since then, I never step on his property. And anytime I'm walking my dog, soon I get to his house, I turn back around and go back to my house, and I shorten my walk. So, and I have his permission, then I take my dog on his property and go for hiking. So, and then I bring him back.
I have just additional question. Understand you are currently having 5 dogs under your house, and 2 is professionally trained for a specific area, and then some foster. So what is your plan or intent to have like a maximum amount of dog? Will you be increasing the numbers of dogs if the business expand?
Ma'am, our business model is like we bring, once we get the contract, we have lead time. We train the dog for maybe 4 to 6 weeks on the substance, and then we send him out on contract. Our dogs will not stay, our professional dog will not stay at the facility. Plus, all the training will be done in controlled environment, and there is no public access to any of our training. It's strictly confidential. As far as Mr. Zach brought the explosive and the narcotics and stuff, it was all ATF compliant in the approved magazines, and the ATF inspector did inspect our facility and approved of it. So, and the area will be fenced, and we're not boarding, we're not dealing with private clients, we're not breeding, there's no breeding program, you know. So it's simple, we'll bring the dog in, we train him, and we send him out on contracts.
But at your facility, your kennel, you have no plan to do additional training at your kennel, that's correct?
Yes, ma'am. We're not bringing 50 dogs or 60 dogs or none of that. It's one or 2 dogs at a time. They get trained and they go on contract.
I just want to add the maximum allowance for the kennel. We've superseded what the requirements are, and we're actually allowing for that little bit of additional extra footage, like on the inside and outside of the run, which then would bring our kennels down to 6 kennels rather than 8, which we could fit into that space.
And one more thing that she did point a gun at me, and her son as well. I didn't call the police because it's not the first time someone pulled a gun on me throughout my police career or the Marine career. So it's not a big deal to me. And I wanted to keep the peace in the neighborhood and be nice to the neighborhood and cooperative with neighborhood. And I love these people. I highly respect these people. Whatever they want, however they want, you know, I'm willing to accommodate. And I hope they would, one of these neighbors would come to me. And there's one gentleman here who didn't testify. We invited him, and I personally mailed all the letters. Whatever was listed, there were 40 of them, and I mailed all of them. And for him to say that someone didn't receive the letter is totally beyond my comprehension. Mr. Harlan is here, and we sent him a personal text. We invited him to the meeting, and we sent him a personal text. Is there any questions and concern? Can we work with you? Do you have any complaints? Please let us know. We're more than accommodating. I understand we're new in this neighborhood, and I responded to over 80,000 911 calls, and I know these neighborhood disputes are never ending. I don't want to live like that, and I don't want my neighbors to live like that. And I want to work with them. So I'm open to all kinds of suggestions, any kind of compromise. So please let me know if there is any personal reason. This business is not only the future of my family, it's the future of these employees and their kids. So it's very important for us,
Are there any additional questions? Okay, do you have anything in closing?
I do not.
Okay.
Thank you.
Then we'll close the public hearing.
Thank you, ma'am.
Thank you. And we'll discuss.
sort of back and forth here, it reminded me, and I was able to remember the name of the case and pull it up. This was a long time ago, but I remember reading it. A guy named Richard DeMumbrian, who operated a historic home business. Part of that case involved complaints, issues, concerns about things that weren't related to the items that are at issue when you're considering a special exception. I think we heard neighbor complaints. What I didn't hear, what I saw in the video, what I heard and observed, is stuff that happened off property, stuff that happened outside of the confines of where this proposed kennel would be. So while I understand that there are neighbor disputes, and we never like to see those, especially when it involves brandishing of firearms, but I don't believe any of that is germane to our consideration of whether to grant or deny a special exception for a kennel within Mr. Qureshi's property.
We're all kind of quiet.
Yeah, I agree with Mr. Bradford's point because we are discussing a special exception tied to property proximity to neighboring distance and so forth. So all this incident and testimony is outside of what we would consider for the special exception. I do agree with that. But, at the same time, every resident of the Davidson County has to follow leash law or command. And the video clearly kind of states, it seems like it's not really following the command. And because of the type of the dog or nature of the dog, I'm afraid for the dog because they may be, just wanting to say hi and sniff. But people who are facing that situation, they wouldn't know what kind of communication dogs are trying to convey. So the next time they may react. So that's what I'm afraid of, which is really outside our purview.
Yeah,
but,
and that, and I think that's exactly right, that it's not, that doesn't matter. Because even in this DeMumbrian case, the Court of Appeals has said, the BZA can take into consideration prior activity at the location in the context of the impact of those activities. So the court said, if there's non-compliance or if there's issues at a specific facility, that's something you can take into account. But what somebody does outside of the context of the property is just not within our authority, and I think we would be, acting in an arbitrary manner to deny it based upon video evidence and other evidence just not within the purview of what this is. So I think we have to focus on, because a lot of the verbal testimony that's been on both sides today is related to things that, frankly, I just think are not germane to the consideration of the factors that are the general factors in 150 and the specific factors for a kennel that are set forth in 175.
So with that, I would like to see the size of the run and fence, because with that large dog, we'll need adequate run to exercise. And height of the fence will be important because some dogs are really capable of jumping off, 4, 5, 6 feet high fence. And so the information I received from the drawing, it seems to me not really enough. I would love to have, more detailed measurement. So I'm literally on the fence of the fence proposal.
And I will say too, like, I completely understand Mr. Bradford's well-spoken point. I will say that, like, you know, we hear a lot of different types of special exceptions, sometimes about daycare, sometimes. I remember one for someone who wanted to have a campground and a bunch of neighbors showed up and talked about the neighbor's behavior. I agree, like, the back and forth about guns being pulled, walking, all that stuff, I agree that that's not germane. I think where I do have a problem, because we had the same issue with a daycare, I think, in Madison, like, before I went on leave. And they showed a lot of video evidence of, like, cars parking on the street where the woman was, like, sort of was running the daycare under a different permit and she was trying to enlarge it and they were showing non-compliance, like, and we looked at her behavior and said, hey, to those neighbors, if she doesn't follow these conditions, you can come back with the show cause order. The only reason why I think this is a little different from the DeMumbering case is that, like, the activity that the video showed, I'm not talking about the back and forth, I'm not talking about the testimony. The video showed, like, I mean, a kennel's directly related to, like, dog training, and these dogs who are trained are walking in other people's yards, they're walking without a leash, seemingly without voice command, and I think that's directly related to a kennel when you're gonna train dogs on site. So that's my only thing, like, I think the activity we saw is so closely related to what they're asking us to approve, it's hard for me to get over that in my mind, because in other special exceptions, we've looked at the general and the specific, because there's two standards, and the general one is just you check off the boxes that you meet. I think they meet those. You check the boxes. I think the one where I'm hung up is that very specific standard, and whether or not it injures other properties, I think that's the one I'm still wrestling with in my mind. I'm not saying that I can't be tipped over. I'm just saying that, like, based off of everything that was presented today, I don't know. I mean, there's only 4 of us. I don't know if I can give them my 4th vote today. I'm not saying that you're wrong. I'm just saying that's the part that I'm wrestling with in my mind.
Totally. And the timeless art of persuasion. What I will say is, I think that the key difference because I get it, you know, it's the same business and the videos are concerning. I'll say too, I mean, well, and I'm also not like, I'm not an expert at training dogs. I don't know what voice command or not, you know, a dog could be running and you could say its name and if it promptly returns, I mean, it could appear to be out of control, but you can say the name and they return to you promptly. I mean, that's a nature of it. I tried very unsuccessfully to put my dog through dog training at one point and it poor thing just didn't take. The key is that the case, it references that activity at the location. So I think, you know, if we were talking about the daycare, I think is a good example. Parking issues at that spot. If there's non-compliance at that spot, I think that's where it's a different than someone, you know.
On the street, like, a lot of those people, it wasn't at that spot, it was like in front of their house on the street. It wasn't technically at the.
Saying, like,
yeah.
it wasn't technically on their property. It was neighbors who lived next door across the street, and they had issues of the parking in front of their house. I remember specifically, like, they had issues with, like, the pickup and the drop off. Again, I'm not arguing the point, but I'm just saying, like, it overflowed into the street, and that was so again, I understand what you're saying, and I think you're, like I said, the testimony about guns and I didn't really, because I don't think anybody was more credible than the other. I believe the applicant in their testimony, I believe the opposition, like, I'm not gonna get into that. I think my main hang up, I'm just telling you, is the video. I think that's my main hang up. Like, everything else, I think my main hang up is the video, because it's like, if you're if we have video showing that you're not necessarily, because it looks like the dogs were just walking in people's yards,
and
which they're not allowed to do.
And I can't tell if that's a non-compliance or if that's
because once we approve it, it doesn't come back to us.
Well, and the other thing is the nature of, like, if a dog is if you can verbally command the dog to return, I don't know that it's non-compliant for, you know, so I think, and I will say, that one thing is, to Ms. Johnson's point that you'd made earlier, I do think, I haven't seen the plan, and it sounds like there was maybe a submission of a plan.
And also, Mr. Bradford, I think maybe we should read the room. I don't know where Ms. Johnson and where our chair is, because it might be in their best to defer this, get with the neighbors, come up with conditions that everybody can live with. That makes it easier approval. They get what they need, and then the neighbors feel like they have some buy-in on the conditions. Because I'm reading the room. I could be wrong, but I don't know if they're going to get 4 votes. And I'd rather us denying it and them coming back. I'd suggest a deferral. Come up with some conditions with the neighbors that everybody can live with, where they get their kennel and the opposition gets some checks and balances that they feel good about, and then we can all,
Ordinarily, I would say conferring with the neighbors is something I would recommend. I am not, frankly, just based upon the tenor of the discussions here, I'm not saying that that's going to be a fruitful activity.
Okay.
But I do think that we have the ability to defer, and that if there's additional information that gets submitted to us, we can have a.
Well, then I would suggest even if they don't confer with the neighbors, I would suggest to the applicant that they come up with conditions that they can live with to run this business. I would probably suggest, keeping the dogs solely on your property. If you're gonna walk them, probably walk them with the leash. Those are the things I would suggest. Again, I'm not in their shoes, but just to try to get to a path of approval where everybody can agree with it, and we put conditions in place where we feel like it satisfies the specific condition of because we do have testimony. We have testimony from the one neighbor that was good testimony for them, but I also have that other testimony too. And so I just think that's my suggestion. I could be wrong, and Mr. Bradford doesn't look like he agrees, and so that's fine.
No, I agree. No. If you're saying it for a deferral, I don't know. I think that the credibility of the testimony versus the relevance of the testimony is kind of where I am on what we've heard in each side. But again, and that's because of what the code says you look at and consider, and what this case says you look at and consider. And so, but I also have no issue with a deferral, just given that we're light on numbers, and it might be that more than 4 are needed to render a decision.
I guess I haven't said much because I'm not sure how I would vote. I mean, it's very disturbing to see the dogs loose and running after people in other people's yards. But then again, I don't think that should prevent the kennel. But as someone who has been bitten by a dog, it's very hard for me to see that. And it's very upsetting. And it's very upsetting that Metro has the law that they have. I didn't realize voice command was a thing. I believe all dogs should be on leashes. A lot of people in Nashville have been bitten, and this is not good. Guns, biting, someone's gonna get hurt. That's not our purview, I understand, but I'm not sure how I will vote. Honestly, what I wish is the fence enclosure would be made bigger, the dogs could run around, be happy, not worry about neighbors pointing guns at them. They would be safer, they wouldn't bite anyone, you wouldn't get in trouble if they bit someone. I don't know if they would, I don't know the dogs, but that would be my wish. But again, we're this quasi-judicial board, my wish is probably not gonna be granted.
Well, I also think that what we've probably said is if we are gonna defer this, that and I'm looking at the plan, I'm thinking that maybe we want something with a little more illustration, sort of something visual to show, because there's a lot of property here. This is a big lot with lots of land to demonstrate the runs that we would want to see. Honestly, frankly, the kinds of things that would allow the free roam and training space and voice command running areas without a leash within the fenced in enclosed confines of this property, that frankly could solve a lot of these issues that have come out today. So I would move that we do I don't know if we've had a couple 2-meeting deferrals. I don't know how robust our docket is on March 6th. If we're you know, if we're screwing it up by doing that, or if we want to just do a 1-meeting deferral. Yeah, okay. I mean, it sounds like that if the goal is to flesh out a description, there's a written thing that could be translated into some sort of, you know, visual illustration drawing concept of the way that it's going to look.
We're happy to provide a more detailed drawing. I mean, some of the other things, I just don't know how they can be alleviated. But certainly if you want to see, I mean, I do think the run that we've shown, and I recognize it's a handwritten drawing, is larger than what the code requires. But if specificity and, you know, a computer-generated drawing would help, then I think we're certainly willing to defer and provide that.
Probably at least some dimensions. I don't recall seeing dimensions.
Yeah, there are dimensions, but that's okay.
It sounds like to get the 4 votes, it might be in your interest to pull together some more specificity. And I mean, is a 1-meeting deferral sufficient?
I think we could definitely do that in 1 meeting. I would just ask if there are any other potential conditions. You know, we'd like to be able to think about those. So if there are things that the board has in mind, I would like to know what those are. But otherwise, I'm certainly happy to provide more specificity, more, you know, just computer generated, really.
I do have a request, but I need to ask our legal counsel before if that request is proper or not. So 1 meeting deferral will be your benefit.
Okay. So that's the 20th.
20th.
Yeah, the 20th. Yeah, I think it's pretty clear where I am on this, and so I don't have any further requests.
I would just take into consideration all the discussion today, if you want to think about conditions. I don't know that we're going to write out any conditions right now.
I mean, I hear you. I just can't fix that.
And we'll have hopefully more board members here as well.
Yeah. And I guess I should say, I mean, you know, operational controls remain available if any of these things were true. Codes can be called. Animal control can certainly be called. You know, we've never had contact with animal control. I mean, and I'll also say these dogs are dogs that are in large crowds like airports and large events all the time.
Yeah, it's just hard. I mean, it's just hard for us to know. We don't see the dogs. We don't meet the dogs. We're just.
I know.
I'm just concerned. I'm just a concerned citizen at this point right now. But I wanted to see if you had anything in closing, or do the board members have anything else?
Second.
Okay, there's a motion, there's a second. All in favor, say aye, raise your hand. So 4 in favor for the deferral.
Thank you.
For those parties present, this is your notice, February 20th in this room at 1 p.m. And Mr. Bradford, for answer to your question, we now have 11 items on the 3-6 agenda.
Glad we didn't add a 12th.
Members, last case on public hearings today is case 2025-10. Mr. Josh Bergener is the appellant owner of the property located at 2308 Woodmont Boulevard. Mr. Bergener is requesting a variance in the side setback requirements in RS40 to construct an attached carport or porte-cochere referred to the board under section 1712.020A. Are there any parties present in opposition to case 10 on Woodmont Boulevard? Seeing none, just the folks from the prior case. Mr. Bergener, I'll give you 5 minutes. Let me go back through our testimony. Members, this board granted Mr. Bergener a rehearing request previously, so kind of remind all the members present, this is a new case. So although the items from the prior case do not come over automatically, I don't expect you all to remember everything that was said at the last testimony. So it's also to Mr. Bergener, he's new at bat, if you will. I am going to show the photographs from the prior case because I did not go out and shoot new photographs for this case. And I brought over the, oops, let me zoom out here from the prior. All right, let's see here. This is Mr. Bergner's, man, I apologize, having a little trouble here with my pointer. There we go. All right. This is Mr. Bergner's property located here. Subject property is located on north margin of Woodmont Boulevard. Proposed construction will be over on the right-hand side of the residence, and then here.
Sorry, if we could ask the folks who are in the back to step, so we can hear. Thank you all.
Just out of earshot there. This is the drawings that were submitted in the original case. Has there been any alteration to those design? Okay, just want to make sure the proposed structure be located there. What you see, and zooming in for a little bit of detail. Mr. Bergner's requesting 5 foot 1 inch proposed setback, and we measure setbacks on these type of structures to the support column. The eave that overhangs that support column is a permitted setback obstruction in the zoning code, so long as that eave doesn't exceed 24 inches. And you see they've marked the setback line on the, oops, well, it won't let me do a pointer and a zoom. Interesting. See the dashed line denoting the 15-foot setback required. And then view originally from my visit to Mr. Bergner's house. And then the adjoining properties on either side. And then a zoomed in view and a copy of the elevations submitted for his plan cover. Make sure I get all those. Yeah, there's the existing perspective and then the perspective from the front. So, all right, with that, I'll turn it over to you, sir. And
Thank you very much. I'll be brief, and I appreciate that you all have had a long day. My name is Josh Bergner. I own 2308 Woodmont Boulevard with my wife, Lindsay. I believe you all have been provided emails of support from 3 neighbors, including the neighbor most impacted at 2306 Woodmont Boulevard, as well as an email in support of this from our council member, Brenda Gadd, who couldn't be here. In addition, I'd like to submit 2 photographs and a parcel viewer, and I have copies for the board of the porte-cochere that is at 2318 Woodmont Boulevard, which has a porte-cochere that is very similar. Oh, no, so each folder has, yes, there's a copy of each. Apologies. What you're seeing is 2 pictures and the parcel viewer of a property where this board granted a very similar variance request back in 2017. When my wife and I purchased the parcel back in 2017, we didn't position the home, which is not centered, but rather was constructed on the right side of the lot, which limits our options in terms of providing what we're looking for, which is to allow our family to ingress and egress into the house without being exposed to the elements. As it currently stands and without the approval or approving the requested variance, our family and guests wouldn't be able to do so. And I have my representative here, Chris Strickland, who can discuss some of the specifics of that. Again, I would just highlight that this, there is no opposition. Our neighbors are in support of this. This board has previously granted a similar request. And I'd also like to just note, our thanks to our council member, Brenda Gadd, who has supported this and has been very helpful. With that, I'll turn it over to Mr. Strickland to provide some specifics.
Hey, my name's Chris Strickland, architect. 406 Bushnell Street is where my office is. As mentioned, Josh had asked us to, we're tasked with providing or looking at an idea for a sheltered egress to his house. We looked at doing this in the front of the house. That made no sense because we're already at the setback, the front setback. And doing an intervention at the front yard of the house just made no sense architecturally. It was a long run from the drop-off point to the front door. That didn't make sense. We then studied going to the back of the house. If you drive to the back of the house and try to put a porte-cochere, one that's large enough to a true porte-cochere, not what's shown there, to the back of the house, ingressing is not a problem. Egressing is a problem. Trying to do a 3-point turn, it turns into a 48-point turn to try to do that, to get out. So when we talk about the physical and unique characteristics of the property, it's the existing garage storage building that is more or less causing an issue with egress. So looking at the best place to put this porte-cochere would be on the side right there where it's currently shown, where this was the determination we came up with. And we'd like to point out that the other part of this is that, again, the house is not centered on the property. It's to the east 2 or 3 feet from center, which is not, it doesn't seem like much, but when every inch counts, it does make a difference. And then in summary, I would say that, the hardship was not self-imposed. It was existing on the property. This is not a negative impact to the neighbor.
I'm sorry, I'm sorry to interrupt you, but I just want to make sure I understood you. Would you say the hardship is like how the house is centered? I just want to make sure I understood.
Partially, yes.
Okay.
The compounding effect of where the house currently is and the house and the accessory structure behind. Thank you. The hardship's not self-imposed. We're not doing this for any kind of financial gain. We're not adding square footage. There's no negative impact to the neighborhood. In fact, the neighbor next door fully supports the proposed addition. No harm to the public welfare. And I feel the proposed addition does not compromise the spirit or integrity of the zoning code.
I would just add, and the reason that I provided the parcel view of the property where the variance was previously granted is it indicates that a detached garage in this particular part of Woodmont is unique. I don't believe, at least based on the parcel viewer, that there are any other detached garages, which again is what is providing the difficulty in placing the carport somewhere other than within the setback. If the board has any questions, certainly we're trying to provide as much information as possible. Again, this variance is not being requested for financial gain. It's consistent with the home's architecture and that of the overall neighborhood. It is supported by our council member as well as the neighbors, and would ask that the variance be granted.
There was a reason that you wanted or needed the carport to be attached to the house. What was that reason? Was there a health reason? Or?
Yeah, so I have aging parents. And so, as they get older, that 40 feet from the garage, it can make a big difference. So, between them who visit very frequently, other guests, I have kids. So, being able to get in and out of the house without being exposed to the elements is a big part of this request, and really the primary reason for the request.
You're out of time, but I'll ask if there's any other questions. No, then we'll close the public hearing and we'll discuss.
I have a question to Joey, though. Is there any regulation change between 2017 to 2024? Because I'm just curious why 2017, those portico share was approved is there any regulation change?
Member Johnson, I'm not aware of any code changes between the two. We do now have a code that allows for covered porches in a street setback as a permitted obstruction. But I don't have any that would have changed on the side yard in R40.
Yeah, I'm trying to understand the rationale because looking at the, the parcel viewer, seems like the house with this already approved portico shed is shifted to east side, similar to this property. And it seems like at that time, probably portion of the portico shed, was within the side setback because those neighborhood is pretty much all same zoning. So I'm just curious why, back then it was approved.
Yeah, I'm not sure, and part of the new evidence upon which y'all granted a rehearing was at the time of his original, we wasn't aware, but our records do indicate that the zoning board did approve a variance on a side setback as a similar request to what Mr. Buckner's asking for. The street address is escaping my recall sitting here.
2318.
Okay.
Well, it could be there was some kind of hardship that warranted it, or.
Yeah, I'll admit, I was not, I didn't work for Metro from 2015 to 2020, so I don't know what happened there. I did keep up with the board because I brought clients here and represented them, but I don't know. I don't know, but obviously, you guys have in the past looked at, hey, the house is sort of just off center, whatever reason in the 40s or 30s they built it that way, I don't know, but that's obviously not it's not self-imposed by this gentleman, so. And as I told him, it's, it didn't seem unreasonable to me, but I don't have a vote, so, at the end of the day, it's up to you guys.
Yeah, just because it was approved, I don't know that it's apples to apples because
I'm looking at Parcel Viewer and seeing the parcels side by side, and it looks pretty apples to apples to me. It looks like the houses are placed in a pretty similar place, and the lots are basically shaped the exact same. So,
I don't know that we can approve it on a precedence, but it does seem like there's some other reasons to approve it.
Yeah, right.
I agree with you. I'm not really comfortable because we always tell people that those prior decisions don't have any presidential value. Not presidential, y'all know what I'm saying. But I do think that there's a path. I think they presented enough to, the gentleman who spoke, not the owner, but the other gentleman, when I asked about the variance, the placement of the house, they didn't place the house there. The placement of the house creates a unique hardship that justifies the ask, and I don't think the ask is, I think they narrowly tailored their ask to what that hardship is. So I'm comfortable approving it, but I will defer to y'all and listen to your collective wisdom.
Yeah, it seems like one of those situations too where we maybe even just inching our way into the portico being a permitted encroachment at some point, the same way that a porch is or things like that. It's basically a covered patio for your car.
With that, I'll make a motion that we approve the variance requested due to the hardship of the placement of the existing house and which was compounded by the placement of the back garage. So.
Second.
Okay, there's a motion, a second. Any discussion? No. All in favor, say aye. Raise your hand. Aye. So 4 in favor, none opposed.
That case is approved on a vote of 4-0. Okay, our next item on the agenda is for our legal counsel at BZA Ethics Training. Members, we are recording this. The 3 members who are not present, I have asked Metro Network to record this so we can provide them a link.
Still mad I can't get CLE credit for sitting through an hours of ethics training here.
Well, Ann would love credit because it's quadruple credit as the teacher.
Okay, fair enough.
Hey, Ann, if you don't mind, you can come on up to. Okay. I always love teaching CLEs because we get quadruple credit.
Oh, yeah. Anytime I'm planning a conference, I always feed myself a panel so that I can get some clock some extra time. Thanks.
Can you hear me all right? Yes, okay, good. Is it not showing up? Mhm. If I need to, I can just email it to you, but hopefully it should.
We'll swap.
Huh?
Let's swap seats. I'll trade you. Yeah, come on back here. I'll play.
One day I'm going to use the phrase prejudice versus probative value when talking about evidence in one of these meetings, because I've always loved that.
Okay, so I just plug it back.
And I don't get to be a criminal lawyer. YouTube recordings of our banter right now, since we're technically live. We really need some windows in here, though. Time escapes.
I'll tell you, for good TV, let's take a quick break and we'll get this up and running and stand in recess for a couple minutes. Thank y'all. my whole desktop.
It's
Well,
still not showing up though.
It's coming up.
Okay.
I had Outlook closed. I gotta pull it down. There we go.
Well, the good news is that we're getting this done, and you don't have to do it again for 2 more years. So, yeah.
All right, here we go. Let's see. Spinning. Yeah, it's not a very big file, so.
No, it's a pretty short profile. Okay, I'm seeing it.
Yeah. I keep forgetting my mouse is. Okay, here we go.
All right.
Okay.
All right, great. Okay, so this should be just about 15 minutes or so. I know many of you have heard this before. It's very similar to what we did a couple of years ago, and we'll do it a couple of years from now. Some of you have also been on other boards and commissions and have heard very similar presentations. So, and a lot of this is also like common sense. I thought a lot of those ethics is just kind of stuff that you would know already to do instinctively, but we're just going to go over all the specific rules because it's just kind of helpful to get those reminders every once in a while. So I'm not going to go read. You can just like click through all those because we go through them in the presentation, so I don't read them again at the very beginning. But there are just several goals to the training, and we're going to talk through all of them. All right, the first goal is to understand that you cannot accept benefits related to your role on the board. And there's a specific section of the Metro Code, 2.222, as the General Ethics Ordinance, and it details a lot of different situations that relate to this prohibition. So as a Metro employee, which you are as board members, you shall not accept or solicit any benefit that might reasonably tend to influence you to act improperly in the discharge of your official duties. You shall not use Metro property, services, or funds for personal purposes. You shall not use non-public Metro information for personal gain or for the gain of any family member or other employer. You shall not use a Metro position improperly to secure unwarranted privileges or exemptions for yourself, relatives, or others. Accept other employment which may impair your independent judgment in the performance of your Metro duty. Accept any benefit which the employee should reasonably believe was intended to influence any action taken in the employee's official capacity. And you also shall not give any reasonable basis by your conduct. You should not give the impression that any person can improperly influence you or unduly enjoy their favor in the performance of their official duties, or give anyone reason to believe that you are unduly affected by kinship, rank, position, or influence of any person. There's a much longer list, but these are kind of the highlights. All right, now there are some limited exceptions to these rules. You can accept, sort of de minimis gifts, for example, like an award, like a plaque, or like a framed letter commemorating your service on a board or commission or something like that. Of course, gifts and hospitality that are completely unrelated to your service as a Metro employee, that is not related to this at all. If you can receive meals, beverages, food, promotional items with a value up to $25 from a single source. Things are pretty expensive, so I don't think not much is going to really fall into that category. Free or discounted admissions tickets from a single source with an aggregate value of any calendar year of up to $100, or tickets with face value in excess of that if the event is a fundraiser for a nonprofit. All right, if there are ethical issues, there is a board of conduct which hears complaints and can render advisory opinions. Any elected official or member of a board or commission can request an advisory opinion regarding ethics. Next slide. There are different procedures. If you want to file a complaint, they can be made to the Board of Ethical Conduct. The Department of Law investigates and evaluates and makes a report to the board. The board decides whether to hold a hearing. If they do have a hearing, both parties get to participate. Let's see, next slide. And then there are a variety of penalties. The board can recommend to council that the person be censured. There can be a recommendation of resignation. The matter can be referred to the DA, or it can be referred to the Director of Law for civil relief. Oops, did it just disappear again? Being very temperamental today. Okay,
let's see, is that the next slide? Let's see. Let's see, so we should be, yes, very good. Okay, so this is actually the kind of issue that I get the most questions about, is issues of like conflict of interest and recusal. So whenever you have a question like this, just come talk to me, and it's really easy to talk through, and usually we can come to a solution. Often these are really fact dependent also, so there's not always like a hard and fast rule. So in general, you have a duty of independence, and so you cannot act based on your self-interest, you cannot act based on any bias against a person or a group of people. You can't base your decision on the interests of the director or contractors with whom your board interacts. I know you might know Nashville can sometimes feel like a small town. You might know a lot of people who come before you, but if you feel you're in a situation where you cannot act impartially with regard to that person, you'd need to recuse yourself. All right, so here are some different scenarios. You must recuse if you're biased based on a personal interest. And the hard and fast rule is if you have any sort of, if you have a direct financial stake in any issue that comes before you, you must recuse. If you're biased or prejudiced against a party as an individual or a member of a group, say someone is business partners with your best friend and you just feel you cannot be impartial, that would be reason to recuse. If for some reason you really just cannot impartially weigh the evidence before you, and that could be, I guess, for a variety of reasons, then that would, if you've prejudged the fact issues, not in such a way that, it's fine to get the case and to read it and to come to a judgment, right? You come to an opinion, that's fine. But if there are certain kinds of issues where you could never come to an alternate decision, no matter what the other factors were, then maybe it's not a case you can really have before you.
Sort of like I don't believe in X, and therefore I will
Correct.
never.
You'll never in any circumstance vote for X because you just believe, yes. All right. There are a lot of scenarios, though, where it's perfectly fine to hear the case. Sometimes you might need to disclose if it's something that you think is in the public interest, that people should know that you do have a connection. Then I always think it's better to err on the side of disclosing if you're not recusing, and there might be, a reason that people would be wondering about. So, for example, look, if you're not going to gain or lose fairly directly, then yeah, of course you don't have to be. You have to recuse. If you do believe you can be objective in a case, like for instance, like say there's a company you used to work for and they're coming before you and you believe, yeah, you used to work for them, but you can be impartial, regarding whatever, matter they're bringing before you now, then that's fine. You might want to disclose, I think actually we had this happen with one of you, that you did work for that company, but it was say several years ago, you don't have contact with them now, you have no prospect of employment with them, in the near future, it's fine to make that clear. All right, so it's also good to always disclose if people are trying to lobby you about a specific issue. First of all, there should be no ex parte contact here. People shouldn't be contacting you about specific cases. Direct them to Joey and his staff, and they can, of course, submit evidence into the public record, and that will come before all of you. And if you feel that for any reason there is any information that's coming to you, directly that other people don't have, just make sure you just disclose that everyone on the board is making a decision based on the same evidence. That's what we're really looking for. And when that evidence is public and everyone understands the basis for your decision.
Yeah, let me, if I could add, and this has happened in years past, well, someone mailed a letter, old school, they sent you something, they didn't send us a copy. We've got to have that copy to be in the public record. So if you ever do get an email or something about a case, just say, one asked, have you sent this to staff? If not, forward it to me. We're fine then.
Also, right, accepting gifts from parties. I mean, this would be up there under the first, set of ethics rules we just talked about, right? You have to be very careful about that. Okay. All right, and these rules kind of all flow together. Remember to disclose knowledge you've received about an agenda item from outside the meeting. You should always disclose. Let's see, this is some of the same information we just talked through, right? Ex parte contact is not appropriate, redirect it to staff. You might have relevant knowledge, some of you talked about past experiences, right? You grew up in a certain area, you drive past a place often, you know a particular area well, and it's good to get that information on the record so people understand where you're coming from and the basis for your decision. All right. Articulating the specific reasons and basis for your decision. This is the most important because if a reviewing court is looking at the record here and looking at the testimony and looking at your rationale for your decision, they're always going to be making sure that you use the right reasoning. And you're looking really primarily, right, at the criteria and the relevant guidelines or laws. So for you, right, as we discussed today in some of your cases, right, you're looking at the variance law, you're looking at the special exception criteria. And I think it's really important to remind yourself, like, what are all those factors in 1740, 370 for variance, right? And, you know, you may not you don't have to necessarily like, read them aloud, but you do have to discuss them. And as we know, like, hardship is a really important one, right? And if there isn't a hardship related to a property, and if you don't articulate that, that's probably gonna be a problem down the road. And thinking about the hardship case law as well, and how it's related to like property, right? And the land itself. Also the factors for, you went a little past, okay. And the special exception criteria also, it's really good just to pay attention to those, to, you know, I would have it, you know, that part of the code open as you are considering the case and like making sure you're looking at those factors and like adhering to the language in the ordinance. Because like the stronger connection you make between the ordinance and those factors listed there and the facts before you, the less likely that a court is gonna overturn you. And of course, right, you're linking those, Joey, you're just too quick here. So of course, you're linking the ordinance to the facts before you. As I mentioned, you can talk about past experience with similar issues, although, you know, as you mentioned also, right, your prior cases aren't necessarily controlling because every situation is different and every set of facts is different that comes before you. You'll have situations, right, where you have studies by experts or observations made by the public. Sometimes that comes to you in the guise of expertise from NDOT, right, or stormwater, right? So, okay, now we can move forward. All right, unacceptable reasons for making a decision would be sympathy for the applicant or people who are opposed to the approval. We have that, you know, we have a lot of times we have neighbors who come in here with a lot of conflicts. And those can be difficult to parse and to kind of wade through and figure out where your jurisdiction is and where you can address issues and where you cannot. You have to look at opposition that's based, opposition that's not based in the relevant guidelines or laws, right? For instance, something that might fall in the jurisdiction of a different metro department, say like animal control, as opposed to what you do, right? So you have to kind of really think about where those lines are and where you draw them.
And won't recall this, it was a little before my time, but we had a case dealing with a rock quarry, and one of the board members was a jeweler in town, and he actually made a comment on the record. Well, you know, I think they meet all the requirements, but I'm sitting here looking out this crowd, and a lot of these people are my customers, and I just can't vote for it.
Yeah, that would be completely inappropriate.
That's a no.
Yes, that would be a very inappropriate reason.
Yeah, the Court of Appeals kicked that back very quickly.
I imagine they did, yes.
Yeah.
But you shouldn't even think it. And if you are thinking that, you should be recusing yourself, right? Like if you feel like you're so uncomfortable coming to a certain decision because of like pressure, you know, and that you cannot be objective, then it's time to recuse.
And related to, just the fact that there's a bunch of opposition here is not a grounds to deny it. If they meet the criteria, you're supposed to grant the case.
And I think you do a good job of that. And it's difficult.
I recused myself from a case where the lead opposition was a coworker of mine and did not want to be in a position of having to be in an office next to someone on a day-to-day basis if I had made the impartial decision to be against said coworker. So
I think, it's fair to feel like you really could not be impartial because like your feelings about that situation would have driven you in one direction or the other. Yeah.
Definitely on just one more note on recusal. We had a board member in the not too distant past who we went through the entire meeting, and then right at the end she's like, "Oh, I need to recuse myself," and I'm like, do it up front. Let's do it right at the beginning, get it over.
And it's fine to do it like right before that particular case, because I think if you announce it in the very beginning of the whole meeting, people will forget. But don't participate in the discussion.
Or even if that case, you know, shows up like 9 times in like 9 consecutive meetings in a row, you
should remind everyone that you're recusing. Yep. You can stay here or you can leave. It just sort of depends what your preference is. If you stay here, you can't make a lot of faces that like indicate how you would rule. Okay, just I had a separate slide up for the variance. You know, technically, like you need affirmative finding of fact. It's important to like think through with the variance that at least none of these criteria are being overlooked in a way that someone might pick up on later and say, hey, you know, this was an important fact that was before you and you didn't address it when you looked at these variance criteria. So that's fine.
But like we can give weight, like if it's one, because like some of these are like completely inapplicable in a given circumstance. So.
Yeah, I mean, you can absolutely like weigh them depending on the situation. And I think we always know you always have to think about the hardship, those characteristics of the property. Yeah, and so, yeah.
One thing I'll add too, and it was brought up today, you've got to find all of these. Courts have ruled any of these are applicable. So if you get, you've demonstrated exceptional narrowness, shallowness of the property. I don't have to also prove that it won't. That's part of your deliberation. Yeah, he might have these factors, but it's going to be so injurious to the neighbor. Or, you can have those, but it's not a checkbox. If you get 4 out of 7, you should turn it down. The courts have held if you've got valid hardships, you have to weigh these hardships against each other. But it's been said a few times here recently that you got to have all 7, and courts just have not necessarily seen it that way. As long as you've got a valid hardship and you've done the analysis to weigh items, you're going to be in good shape.
Well, the ordinance does refer to that affirmative finding of fact on each standard. So I think when you can, err in favor of just discussing them briefly, I would say. Better to cover all your bases.
But we could make a finding that it's inapplicable. It's inapplicable to the facts at hand.
Right, it's very clear that this doesn't really apply, this doesn't apply, we've found that this is definitely applicable here, yeah. I would I would err in favor of discussing more of the.
But do not in your motion say, I move to approve. That's it.
Right.
We need more. Here's why.
Yeah.
Give us a why.
So.
And vice versa.
Okay. Open Meetings Act, you probably know this very well, right? You should never discuss board business outside of the board context itself. Never use email or text or phone calls to discuss board issues or invite comments from other members. You have to make sure that it's fine to use your personal email. I advise people to create a separate email account that where your Metro business goes, because if there ever were an open records request, we would be coming to you asking to look at your email and asking for all the, board-related emails that you have, for example. And, probably they'd all just be announcements and links to the packet or something like that. But it's conceivable someone could ask for that, and we'd have to go into your email and get that. So I think it's nice to have it. I would suggest cording it off in a separate email. I know sometimes that's not always practicable, but I would think that would be a best practice. I don't know if you can get a Metro email address. I feel like I've asked about this, and it's I'm not entirely sure if it's possible. I wish it works. I think that would be a best practice for everyone to have a Metro email address. But all right, so if there are violations of the Open Meetings Act, then the deliberations for that particular case could be rendered void. There was a case in which a judge ordered court supervision of a board that violated the Open Meetings Act, so we definitely don't want to do that. All right, next. All right, so what is a meeting? Sometimes it can be confusing because, you might bump into people around town. Technically, it's when 2 or more members of this body come together and you have the authority to make certain decisions and you are deliberating towards a decision. So for instance, it's fine to meet someone at Kroger, and talk and say, hi, how you doing? Oh yeah, those strawberries look great. But you cannot then slide into talking about BZA business. Okay, I skipped over a bit. Adequate public notice must be given for all public meetings, right? So the public can always hear what you're doing. Everything is transparent. And basically there's the standard is sufficient notice under the circumstances that would fairly inform the public of the meeting. And generally we recommend that, notice of the meeting come out the Friday before, at the very least. And you have a policy for, informing ITS about your meetings and supplying them with all of your agendas and minutes and everything like that. And that's, all right, what is not a meeting? Let's see, I mentioned the chance meeting. The on-site inspection, right? Sometimes you go to the properties. This comes up more with some of my other boards. It's fine to go to the property. If you happen to meet someone there from the board, you can say hello, but you shouldn't discuss the case.
But this doesn't apply if literally I'm on a walk through the neighborhood and you walk past something that's got a sign up and,
Yeah.
Okay.
Well, there's no one else there, right?
Right, right.
It's just you. Unless you've invited someone else to come for a walk who happens to be on the board, which...
I have run into Chairman Pepper on neighborhood walks a few times, but normally it involves him saying hello to my children.
Okay. All right, another exception are attorney-client meetings, and those are very rare events. Sometimes if there's actually a threat of litigation, we would have what's called an executive session with you, and that would be closed to the public. But that's a pretty rare event. Okay, so best practices to keep everyone on the up and up. Staff, you do a great job here. They give you a detailed agenda for every meeting, and that's posted. I guess we say at least a week ahead of the meeting. I think under the Metro Code, it's like the Friday before, but I mean, a week is even more ideal. So the public knows, the board can prepare. They give you very detailed staff reports, and actually not really so much staff reports, but you don't, and maybe that's something we could talk about, which might be like a useful practice. You give everyone a really useful packet, but a staff report would also be a good practice.
And it's, for us, the staff reports wouldn't want to do that. I would never agree to that, honestly, because I don't want to prejudice you. They're here because A, they have to be, or they've been denied a permit. So for me to deny a permit and go, yeah, we really ought to approve that, I'd rather them make that argument to you. Me be more of a referee with, here's the facts, here's why we did what we did, and y'all can decide if there's a hardship. Planning commissions, there are some jurisdictions where the planning commission acts as BZA, and they have a professional staff, and they sometimes write staff reports. When I worked for Gallatin's BZA, and we wrote a staff report, but Sonny's policy was always kind of, and I think a good others should do. We've already said no. They're only here for a variance case because we told them no, and the other types they're here because by ordinance they have to be here. So it's better for a code department to just remain impartial and say, hey, it's your decision. Put the burden on the applicant to prove their case. So.
Yeah, well, staff report, actually, when you come up here and do your presentation, you're effectively doing
the
my
staff report is that,
and
is the presentation itself.
Yeah, you can always just write up something short too, but that's a matter for the board to decide if that's something they feel that would be useful. So we put that out. That's one of the best practices we suggest. And I guess also you could argue that it's given in oral form, right, when you present here. Let's see,
I think that the staff report thing, I've seen other boards where it appears to be that the board is more often than not deferential to what the staff says. And while I appreciate our staff endlessly, I also appreciate their recognition of our impartiality and our sort of decision-making on weighing things. So I'm inclined to agree with Mr. Hargis's.
And if I really disagree with you, I'll sue you, so it's fine.
Well, I wasn't thinking of a staff report as recommending a decision to you, but more like chronicling what has happened in the case to date.
Here's the facts.
Explaining what the history is. So that was what I was thinking, more along those lines. All right, I think we've gone over everything here. You basically, it's good for you to understand how the staff works, what your duties are, make yourself familiar with all those things. Come to the meeting prepared, having read over the agenda and the cases in the packet. Ask questions. Always feel free to ask questions to staff, ask questions to legal. And, one best practice we say is consider adopting metrics to, I don't know if that's something that would be useful for you or if you actually already have those. Sometimes sometimes staff already keep, records, but that's a decision for the board. If there anything if there's something that you want to know about, like what your board is doing, like how often are things deferred or, how long does it take for cases to get resolved or, I'm trying to think of something else that would be useful. Like how often do you grant a variance? How often do you deny it? Like, I don't know, things like that. But that's up to you to decide if that's information that you want from staff. Any questions? You good? All right.
And if we are looking at board rules, do we have a mechanism for if we see something that we want changed in a rule, we can have that placed on the agenda to discuss at a meeting to say, hey, I think we should, because frankly, I think, and I've discussed this, it seems like occasionally we have issues where a party ends up getting the short end of the stick because of varying attendance issues that prevent, the votes one way or the other. And it seems like that's maybe an unfair outcome for the party if it's based on, board member availability. And so if there's a way to, adjust that to make it less unfortunate for folks and from a, that standpoint.
Yeah.
You mean like a case getting deferred because it doesn't get a
Well, like,
number of votes
if
because you have like.
it dies, if it dies on the vine because you haven't had, you've had absences that have not led to the ability to have 4 affirmative.
Right, and you can, those instances, usually those cases are deferred, right, to see if you get the requisite number of votes. So they do have that kind of second bite of the apple at the next meeting.
Yeah, we just have to weigh that against the code itself. The code itself, the failure to obtain an approval of 4 affirmative votes in 30 days is actually an ordinance. It's in the zoning code itself, so we can't alter that.
That would have to be amended by council then.
Yeah.
But that's something. I will since we don't have any business on March 20th, I'd like to keep that day open. Please attend. I will send with you guys here in the next week or so the proposed CURS clean version of rules that Ann and I've worked on. And then y'all feel free to mark them up. Don't email us, but come to that meeting on the 21st and, tell us what you got. And then we'll make notes and we'll reconvene.
So if we mark them up, we need to bring them with us. We shouldn't send them to.
Yeah, you're welcome to send them in
advance.
Yeah.
That's fine.
The big thing
not among
I don't
each
want
other.
you guys.
Right,
Exactly.
but
You can send it in advance to us.
Okay.
Sure.
Yeah, send them to
Especially
us,
if there's a
absolutely.
question like, oh, can we do this? Like, is this legal? Like, yeah.
I love
And then we can-
redlining things.
Yeah, well, yes.
My people in my office make fun of me. I am not good at track changes on Word at all. I'm just not. I don't know how it works. I'm ashamed to say it because I used to be a big techie and a nerd and an IT guy, but I just don't get it.
If
So
you
I
have
print
more
it
than
out and I
if
change
it's more
it
than
and I print again.
2 people working on a document, it doesn't work. It's a
I
nightmare.
can't do it.
Because all the different colors, right? And they
Awful.
change colors when it goes to the
Yes.
other person, it comes back to you.
And then it prints and I can't get these gray bars off the side of it. So I just end up save as and start over. So that drives people crazy.
But
I'll
if you
provide that.
If you do have ideas, Joe will circulate the proposed rules, and there's a red line version of it too. I sent you, I think that, right, so you can see it's so different from the old rules though, just because like there was some extraneous material that really needed to come out. And I think some things were just reordered, and so it will look like a lot of red lines when you look at it. So maybe it's easier just to read through the clean version, and it just kind of brings it in line. So it just modernizes it, so it looks more like the rules of other boards and commissions. And this is a great time to like put in all your suggestions, because you don't want to keep amending it like every few months. It's a pain. So this is a great time to list. Yeah, I think we'll have that session. And you may not vote on it at that March 20th meeting. Maybe you'll vote on it at a future meeting. It just depends on what you want to do.
Yeah.
If you are all in accord, fine, you can. You can also defer it if you want to think about a few things, because it's a lot.
And it'll be a public meeting. And public invited to attend if they want to come.
Yeah. Probably won't be a big crowd.
Not a public hearing, so we won't open to them. But anyway, okay, with that, we are adjourned for today. Thank you. Oh.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.